It's just the good news is the sooner we start, the sooner we finish, the sooner you go home. So everybody is benefiting. My flight is not till 11:30, so I can really be here till 10. So you kind of don't want to. Okay, thank you very much for being here. My name is Asil Zamo. I'm very delighted to be here to do this training for the Mediating the Moot. I don't know the problem as well as you do, so I'm going to rely quite heavily on your knowledge of the problem to make this session very, very successful. Before we start, I just want to share with you objectives of this workshop and a bit of an overview of the session. Also, give you a little bit of background about myself. I usually sit as an arbitrator, so I know what you guys are going through because I watch a lot of lawyers do exactly what you're asked to do for the Moot. However, my heart is all about mediation, and I'm hoping that the passion I have for mediation, Michael too, my friend at the end of the room. So we're just kind of surrounding you with mediation on both sides. This is like purposeful. That this passion is transferred to you, and you become big champions to mediation going forward and in your careers. And actually, what's really, really interesting, I just got an email before I walked into this session of one of my arbitrations where the parties have sent me an email saying we now have got full and final settlement. So it's very, very useful when lawyers really see the value of settling disputes away from arbitration and litigation. And I'm going to give you lots of examples about that today. What we're going to do, we're going to try to cover, usually it's a training that's a much longer, called mediation advocacy, or as my friend Michael's likes to call it, mediation representation, which is the role of the lawyer in mediation. And so that's the focus. The focus is not what is mediation in general. Obviously, what is mediation comes in because you need to understand the process, but it is aimed at aiding you and giving you skills necessary as lawyers to be able to support clients in the future in mediation. In exactly the same way as a Moot is training you to plead as lawyers on behalf of your clients. And so that's the process that we're trying to do. So I picked the exciting part of the longer training to share with you today. And at the end, as you can see, we're right here in front of us, mediating the problem. Now, the great thing about this year's Moot is all of the arguments that you've been working on very hard are procedural. We are not going to talk about procedure in the mediation. We are going to focus on the actual substance. I have somebody say to me, I hope we're going to learn something that will help us in arguments. You won't. This is not meant to help you in your competition. It is meant to give you a new set of skills, which we believe is going to be very useful for you as lawyers in your professional careers. And no matter what you end up doing, those skills will be very, very necessary. And I actually am very happy to be here because it's really exciting. I've sat on a number of arbitration as a judge in the Moot, and this particular section was never there when I was involved. So well done to you guys for actually, the organizers, for actually making this happen. And this is why I've come from Bahrain to actually do that. And I'm happy to see that one of the Bahraini teams are here, which I'm very proud. Right, so moving on, it's not new. The fact that we need to find an alternative to litigation, and now, in my opinion, arbitration, even though that's my bread and butter and that's how I make a living, is not new. It's been talked about for many, many, many years. And in 1979, Chief Justice Warren Burger actually said, we need to find a solution to litigation. Litigation is very, very long-winded, and it will, no matter with the best interest in the world, it's going to take time. In my previous life, till very recently, I was the advisor to the Bahraini Chief Justice and the Minister of Justice. So my job was to actually make sure this works, litigation works, making it fast, effective, and efficient. And no matter how hard you try, it's going to take time. There are a number of levels, there are procedure, there is structure that you must follow. So fast is just not possible. You can't just zoom through a litigation. People need to have their moment in court. You need to apply due process and all of those really important things. Unfortunately, that leads to costly, painful, inefficient systems, no matter how hard we try. And I want to remind you that we are in it for the parties. Even though us lawyers think it's all about us, it isn't. There are real people, real companies, real individuals, real livelihood behind those disputes. And those are the people that we are here to serve. So we as lawyers, judges, arbitrators, court staff, everybody's main task is to serve those individuals and to be able to give them an answer to their disputes. Part of my job was my Chief Justice every morning saying, do you know justice delayed is justice denied? You need to find better ways of getting it done faster. I think the best way to find justice is to allow the parties to find their own solutions, which is why we're doing this today. So I don't need to spend too much time telling you how complicated and how inefficient litigation is. I think all of you from your respective home countries have and I know these details. Unfortunately, the alternative to litigation that we've created is arbitration, and it's now quite often very formalistic. As you can see in the Moot, it's a real reflection of reality, and it takes quite a while. So parties are asking more and more for alternatives. And parties that go through a mediation process that hopefully you will see today actually come out much more satisfied. The unfortunate fact of litigation and arbitration is no one really is happy at the end of the day, neither the winner nor the loser. Because the winner, and now got to enforce whatever it is that is being given, which usually is quite complicated, one, have paid a lot of money and spent a lot of time, and the loser always feels that they actually, were hard done by this decision, and they should have won. Whereas we hope to demonstrate at the end of the session that actually both parties walk away from a mediation process very, very happy. I mention ADR because obviously that is, the alternative dispute resolution, which is the alternative to litigation. In my opinion, now we also talk about ADR as an alternative to arbitration. And I want to share with you this video, which I find really interesting because it kind of goes back to ADR history. And I've never really thought about the history of ADR prior to me finding this video. And it really summarizes the mission of people across centuries and generations trying to find an efficient and effective way of resolving disputes that makes them feel like justice has been served in some way. So it's really interesting that this problem is not today's problem. It's a problem that's been going on over many, many, many years. And we've all, as humans, have been trying to find many solutions for them. So I'm just hoping that this technology works. Let's see what happens. God, the silence is scary. Something's happening. I don't want to touch it. I'm assuming it's going to work. Okay, there we go. It opened a different one. It's fine.
Solution encompasses various techniques and strategies aimed at help resolve their conflicts without expensive and lengthy litigation. With a history to 1800 BC, ADR was routinely utilized in the negotiation of distant kingdoms. Greek philosopher Aristotle praised the use of arbitration over the court systems, while ancient Phoenicians included negotiation standard aspects of their business transactions. ADR has also played a significant role in American history. The writing of our Constitution involved extensive negotiations regarding the conflicting viewpoints of the forefathers. In 1923, the Department of Labor was added to the federal government, with one of its chief purposes being the mediation of labor disputes. From there, ADR grew into a widely accepted and utilized tool within the legal system. It is seen as a cost-effective and time-saving alternative to traditional court proceedings. Lawsuits can take months or even years to conclude. But by comparison, most ADR proceedings are concluded in days or weeks. This significantly keeps costs down for disputing parties who pay for legal counsel. In addition to its benefits for the parties, ADR is also beneficial to the court system as a whole. Courts are notorious for backlogs of cases waiting to be heard. ADR provides options.
So the dispute resolution process as a mechanism have been divided into two parts, non-binding and binding, right? Binding is you got to say what it's done at the end, and the ones that are non-binding. And one of the biggest challenges that we face, anybody that talks about mediation, is it's not really binding, is it? Right? If I get this final settlement, okay, so then what if the other side does not form? And that is an important question, and parties are legitimately concerned about that. Many countries around the region have actually got various solutions to this. So, for example, the mediation law in Bahrain says if you notarize your settlement agreement, you can go directly to the execution court and actually execute that settlement in exactly the same way that you would for an arbitration award. So there are many solutions to that issue. I understand the concern that many parties may have of the fact that I need to then sue in court to enforce the settlement. What I actually always find really fascinating is you are going to sue in court anyway to settle, to actually litigate the dispute. Now it's really straightforward. It's written down. We've agreed that you will pay me 500 BDs, KDs, Emirati dinars, and that's what the court is going to look at. There is no real dispute anymore. The court, it will be a lot faster and there will be a lot more efficient to actually finally settle the dispute. But the more important answer to that question, in my opinion, is significantly the number of settlement agreements that are actually voluntarily enforced and actually implemented by the parties is over 50, 60, 70, 80%, depending on what country we're talking about. But that's significantly higher than any other possibilities in a dispute resolution process. And so even though mediation might fall in the kind of non-binding side of the table, however, actually in reality it is binding because there are many solutions to it. Plus, it would actually have got it narrowed the issues between the disputing parties significantly to making the actual decision for the judge, or then if you have an arbitration clause, so much easier. So it really makes a huge difference. Now, I want to ask you to try to help me define. I'm going to give everybody 2 minutes to help define each of those different forms of dispute resolution. Can you also identify what is a greatest advantage and greatest disadvantage? So many of them have lots of advantage and lots of disadvantages. We're not going to spend a lot of time on that. But I would like you to identify the number one advantage. Okay, 2 minutes. I'm going to number one advantage and then the number one disadvantage, right? So I'm going to give you 2 minutes to have a little think about it, and then we're going to have a little round of answers for everybody here, because everybody looks terrified at the moment, and this is supposed to be fun, and your faces are not showing any form of fun, and I'm very concerned. So I don't know if I should be doing a little dance here for everybody to start smiling again. That is much better. Look at that. This isn't. Relax, everyone. We're having a good time. I promise these guys that you will not fall asleep. You know, come on. Don't tell me out to be a liar, please. Right, so 2 minutes, please. You can talk to the person next to you if you like. You can answer on your own, whatever you like. I just would like you to think of how would you define these in one sentence, and then the greatest advantage and the greatest disadvantage. my 2 minutes are up, correct? Yes?
Microphones, and there's some floating around.
Oh, that's perfect. Thank you. Thank you. That's very kind. Right. You really wanted to tell me, so please tell me. Choose one and tell me the answer.
So we choose negotiation. Negotiation is a process that occurs strictly between the two parties and by their representatives. So if in the context of a company, it would be an employee of the company, maybe one of their authorized signatories. And unlike the rest of those examples, there is no appointed impartial third party. So the biggest advantage to negotiation is that it is the least expensive form of dispute resolution. You don't have to hire an independent mediator. You don't have to pay any institutional fees. And the greatest disadvantage is that it is the least enforceable form.
Can negotiation happen with an appointed expert negotiator, like with the third party? Or it has to be only between the parties?
Good question. Any ideas? Room? Yes?
Would that then turn it into a mediation?
Insurance companies and to settle claims, I think is normal to have a negotiator, but that's the choice for the party that they choose to have somebody from outside. It's simply be negotiation, I think.
Okay. Any other ideas?
I'm moving into mediation.
No. Can we settle this? This is a really important question. I'd like to settle it. So what let's agree to answer. Sorry, what's your name? Christina's question is a very important question, and I'd like it answered.
I think it's when the judge mediates between the parties without going into litigation or having a judgment at the end.
So are you saying it's still negotiation, what Christina described? Having a third person in the room?
I mean conciliation.
Oh, no. We're answering question. So remind me of your name. Kareem, explain to us what negotiation is. And Christina asked a very important question. If we bring somebody else to help, is it still negotiation or is it something else?
I think it's still negotiation and not mediation, because if I'm not mistaken, mediation needs to come from a mediation institute, an institute that can do mediation.
Excellent. This is really okay. Coming. Yeah, please go.
I think if we're going to appoint one of the persons to deal with the negotiation, I think it would be rather conciliation as an expert to resolve the dispute between the parties.
Excellent. Yes.
From my perspective, negotiator is not a professional who's not trained to be just a third party who understand both ideas and approach the problem from parties idea. But the mediator is a professional who takes the money and who gets salary for that, and negotiator, if I'm not mistaken, they don't have to be licensed.
Okay.
I think that
coming after him. Yes.
Sorry. Involvement of a third party, I think, does not change the notion of negotiation. And I think that the real difference between negotiation and mediation or conciliation can be described as that when we begin negotiation, we don't really have a final result in mind. We both know that negotiation may not even result in anything. But when going to the mediation or conciliation, it is generally accepted that we may have a result at the end. Maybe we are not happy with the result, and it will not be a mediator's decision or a mediation agreement, but we will have a result. But in negotiation, I think it is accepted that we might not even have any kind of result.
Okay.
Personally, I feel like for negotiation, you can have someone representing you, right? So if there are two parties, they can have someone who are negotiating for their parties together, but it's not someone who's there to mediate between two or make a final decision for both, like in mediation. And adding to what he said, for negotiation, you don't have a final decision or like a final agreement that you want to come up to. You're still negotiating that thing. You're still trying to figure it out. While mediation, you know what you want, but you want to come on like common grounds.
Okay.
While mediating.
Okay. Yes.
I'm on the same page with her, but I wanna at some point first. In negotiation, party can have a presenter on behalf of them, and presenter can negotiate with other. But in mediation or other, the third party involved is a neutral third party. It's about the neutrality of the representer.
Okay. Sorry. Yes. 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 Please.
Okay, I just have a question before I answer. Are we saying that are we saying that the negotiator that they will be hiring, are they there to settle it between them as like a neutral third party? Is that what we were asking?
Yes.
Yeah.
Someone who is expert at negotiation techniques and can actually advise the parties on how to reach a common ground. So the BATNA, for example.
Okay, I believe personally that because negotiating mostly involves the parties themselves trying to settle the situation, if you involve a neutral third party who is not under a mediation institute or something, it would most likely become conciliation.
Okay.
That's in my
So, from what I know, the International Mediation Institute defines mediation as negotiation that is facilitated by a third-party neutral facilitator. So, to go back to Christina's question, and I'd love to hear the answer as well, I believe that if we have negotiation with a neutral third-party facilitator, that turns into mediation. That's no longer negotiation. That's my understanding, but I'd love to know the answer as well.
We will come out with an answer at the end. We're not going to leave the question hanging. Yes.
We're just going to put the relevant part because she's an expert negotiator. So I'm sorry.
But to my point, because my student said, but I used to be a professional negotiator, and while I was a negotiator for my living, that was my job. If you're not regulated by a professional body in that capacity, it's not technically a profession, right? With the legal definition. So I would agree. I would say negotiation. If there's a neutral party, I would say it's tips into conciliation or mediation.
Clarify the view in the room. So the view in the room, if there's a third party, which is the first question Christine asked, first element, we're adding an extra person. So not the parties and not their lawyers, another person, right? A third party in the room. Then it's no longer negotiation if that person is neutral only, or even if he wasn't neutral. What if it's a friend of the parties, some common friend? Does that change the answer in your views? Does the answer that if it's a neutral third party, which is I think the majority of the room says, if it's a neutral third party, then it's more likely it's now moving towards conciliation or mediation. That's the answer. My question is, does the answer change if the person is not neutral? Yes.
Is it that if there's consent between both sides, then it can still be a mediation, even if they're not neutral?
Consent for both sides for what?
So if I consented that this person is biased, but I still consent that they're my mediator, this can still be a mediation.
So your answer to my question is the neutrality of the third party doesn't matter to the general statement I made.
Kind of a question and an answer.
What everybody else? Yes.
I think since third party is not neutral, it means that it is working for one of the parties as the main negotiator for this party. So it means that it will be still negotiations rather than conciliation or mediation, since the person who is acting as a negotiator is working for only one party, not for all.
What if he's not working for either? He's just friends of the parties. Just friends. He's not neutral at all because he's friends with them, but he's friends with both of them. And they are agreed to have him in the room, both of them.
Just to understand your point, I mean, because if it is friend with both, the bias go both ways, so it will be no. So it will, to a certain extent, will be kind of neutral.
Okay, bias balances itself out is your argument. I like that. Good.
Like in math, minus equal plus, right?
Yes.
I think that if the party is biased, especially if you say this is a friend and the friend agrees, this is someone who definitely has a bias. Well, okay, they might do their best not to have the bias, but they do. And so in my mind, that's more of a conciliation negotiation that's leading more on that side versus a mediation, which in my understanding would be a neutral third party. But notwithstanding, I think you can have a negotiator who's neutral as well. But if you have someone who is not neutral, I think that you can't call that a mediation.
Okay, so is everybody in the room in the agreement for us to be in the box here in mediation? The third party, there needs to be a third party in the room. Everybody agrees? That's consensus? A consensus, right? And that person needs to be a neutral third party. Consensus? So if it's a friend and we agreed, we don't agree. Sorry, what's your name? Frico says, bias. He's friends with both. He likes them both. They're going out for dinner. He's not really biased at all because he's neutral. What do we think about that? Do we agree? We don't agree? You wouldn't agree. He's not neutral. Why? Rather than he's not neutral, because let's just ask a question. Does that then remove it from the mediation box? That's the question. Does the friend that is agreed upon by both parties removes this process, this mechanism from the mediation box?
Sorry, go ahead.
Well, I think just the word friend, I think even if it's a friend of both parties, they have a stake. They have they're somehow emotionally invested in the issue, in the problem, and their intervention comes out of their desire to see the parties reconciled. Whereas a mediation, I think the purpose there is that you have someone who is dispassionate, who doesn't have an emotional stake in one result, or even if in a happy result. Okay, I mean, I'm not saying because
really, but if somebody says they take the money, I don't take the money. It doesn't matter
because as you said before, it is your passion as a profession, as a mediator, to bring the parties to a. But I mean,
fairness at the end.
I mean,
make your point.
Yeah, okay.
I'm not disagreeing.
Get my point.
So I would say if the parties are consented to have that person as a mediator, it would be easier for the mediator to tackle the problem itself. Like if there is a consent, they agree to have the person as a friend, as a mediator. I don't think it would be a problem to not get the process as a mediation. I think it happened. It can happen as a friend, like mediator.
So your opinion is this friend can still be the person in the room and still have it in mediation?
Yeah, that's correct.
How many people agree? Put your hands up. Ooh, very few. So everybody else in the room believes that. Sorry, somebody was saying something. Yes.
My remark was about having bias or not, but I would probably put the situation under conciliation rather than mediation.
Why?
Because mediation should be a professional third party that is truly impartial, has no relation with either party, while conciliation can have this link. Although then, I mean, there's always a point to whether how we can judge if somebody is independent or impartial. Even for arbitrator that truly should be independent and impartial, there are cases in which arbitrators have been appointed 11 times by the same party over the years.
And very impartial. They're very impartial.
Well, no, but the court there is case law from the Court of Appeal of Paris telling that that case it's very controversial, but there is. So, but
I'm not disagreeing with you on the fundamentals of that argument. Okay, so all right, so maybe so what do we think conciliation is? Because now all of a sudden we think, oh, maybe it's not really mediation, maybe it sits in conciliation. Somebody you've thought about it. Let's hear somebody I haven't heard from. Yes, please tell me what conciliation is.
Basically bringing together two disagreeing parties and maybe offering advice on how to settle their differences.
Advice.
Yes.
Okay, anybody else? Yes, please.
Well, conciliation is an alternative dispute resolution where a third party, often called a conciliator, offers solutions and proposes ideas on how to resolve the dispute.
Okay, so yes, please. Sorry, apologies. I gave you the mic and I forgot. Please.
I have two things to say with regards to conciliation and mediation. I mean, even if we look at the ancestral model, at least the previous version, they are interchangeable. The two terms are interchangeable. And with regards to the neutrality of the third party, the neutral concept, that depends if we're in an ad hoc setting or an institutional setting, because if it's institutional and the rules require that a neutral third party, then that would apply. However, in an ad hoc setting, it could be anyone. If they agree, then yes.
And can I ask, isn't box 1, 2, 3, 4 driven by party consent? So if we agreed to whoever is in the room, friend or new friend, the parties have agreed. Do you really think that makes a major difference to the process? What do you think now? Well, let's just go back to basics. Box 1, 2, and 3, and 4, litigation, you don't get to choose anything, right? You just find yourself in front of the next person in the row, right? That's how it is, right? So the other 4 boxes, we agree, all of that is based on the consent of the parties, correct? And everything that happens in these processes is completely driven by the parties, right? No, we absolutely, no, oh, go, I've got somebody saying no. Excellent. I like this. Perfect. I like this. Please, say fast. I want to hear it. Please.
So I think that actually arbitration is regulated and legalized in a lot of jurisdictions. So when we refer to the laws regarding arbitration, we can find some mandatory rules. So I would say that everything is not driven by the parties' consent. For example, the impartiality, I think that a lot of rules and laws regard impartiality as a mandatory rule, and they will set aside the award that a partial arbitrator has decided. So I think that not everything is driven by.
So can I just ask a question on that point? So if an arbitrator makes a disclosure and the parties decide to accept that disclosure, despite whatever it is, that makes him impartial for whatever reason. He's been appointed 11 times, 6 by each side, right? Does that 12 times, my math is terrible. 12 times, 6 by each side, right? So that's the disclosure that the arbitrator makes, which, based on our friend's argument here, could make him slightly impartial or equally biased to both. The question is, if they agree to appoint him, or this raised no objection, not even, I will go further, they've actually made a positive confirmation they still want that person. Do you believe the losing party has got grounds to go and annul that award?
So I think that in my domestic jurisdiction, Iran, in the domestic arbitration, I think there is an argument that the losing side could, in this situation, again go to the court and say that the arbitrator was not impartial. But I can think of other situations like the arbitrability situations that I think there is, of course, situations that parties cannot go to arbitration.
Yeah, no, thank you. What I want to say aligns pretty much to what you point out. So focusing on arbitration, I don't think that the agreement of the party can supersede any problem, especially when it comes to appointing the arbitrator. From Italy, my jurisdiction, a clause that would entirely leave the choice of the arbitrator only to one party will render the entire arbitration agreement void. It will not be enforced, and I think even international arbitration, they will not be enforced in Italy under Article 5 2b of the New York Convention.
As you go down that chart, the parties slowly start to give less and less control over the process. So negotiation, parties have the most control. It's most voluntary. With conciliation, we can say, well, now a third party gets to have an opinion on the matter. You go to mediation, now you have less control over the procedure. There are, for example, confidentiality rules, as we see in this problem. And then arbitration, you lose control over the outcome. Litigation, you lose the control over who you choose to hear this dispute.
What do we think, Karim, right? What do we think of Karim's scale? Do we think that's a reasonable reflection of what's on
I
the screen?
agree with him, because in negotiation, it's basically up to most of the times the parties negotiating with each other, right? Even if they're getting a negotiator, they're presenting their teams. While conciliation, I feel like you can get a person to help you, and that person can be a friend, because you're trying to reconcile with each other. So a third party who's a friend or not could help. While mediation, I feel like mostly you would want to agree on a person who is not going to be biased and come to a conclusion and probably like try to go with it. Arbitration, on the other hand, is enforceable. Like there's a decision and you need to follow it. And then litigation, there's no control at all.
Can you please, as we have a negotiator in the room, can you describe your role in negotiation when you're putting that hat on?
I would be trying to reach agreement, consensus with the other side, but with like an equal number on the other side, I would say. Yes.
Precisely. So, absolutely, there are people that are trained and extremely good in actually negotiating on behalf of one side. And there are equally another very good, professionally well-trained person on the other side. Think about almost all disputes between countries, they are negotiated. They have professional negotiators in the room. They are fighting. They are on each other's side. They're sitting across the table from each other. There's nobody sitting in the middle per se. There are two groups of people trying to come up with an answer, with a solution to the current problem. And absolutely, I agree, that is an absolutely most control you can have at all, because it's the two parties agreeing on things. And in the real world, there are no commercial dispute that ends up anywhere near here beside the parties have tried a number of times to negotiate. Nobody disagrees with another person and runs to a court or arbitration, or not even mediation, right? Most parties are going to try to pick up the phone, call for a meeting, a number 3, 4, 5 times until they fail to be able to reach a settlement, and that's when they move on. So we now establish that in answering your question, once we bring a third party into the room, neutral or not, we can argue about that in a moment, is then it is not, and thank you for that question, because that was a brilliant way of going through this. It's negotiation. So now we understand what negotiation is. And actually we do this every day. Everybody that's ever been to a souk and had to do a bit of haggling, markets, yes, any market, right? Where you are, now you can't walk into a mall or a shopping center and say, I'm not paying 5x for this, right? You're going to pay whatever they have on the thing. But in a lot of places around the world, and I'm assuming everywhere in the world, somebody have involved in some sort of negotiation for something. Yes.
I would say that negotiating in the souk is nowhere near as challenging as negotiating with a child in your family. If you have kids in your family, this is the negotiation. The souk, nothing on children.
I just assume most people in this room don't have children. Yeah, but I think there is a negotiation part between a mother and a child that I think is I have to say, being a mother, I've done so many things in my life. Being a mother is literally the single most hardest thing I've ever done. I find it the most challenging. I've had no skills training in it. You can't look in a book for the answers to what this person is doing. Right? There isn't an answer in a book. So yes, you're absolutely right. So what's your name? Hilary is right. That is literally goes ranks in the top. But just to give you an idea, every time you've had to, with a friend, where you're going to agree where dinner is, right? If both of you are really, that is a form of negotiation. And actually, it's really good skill for life to learn. So anybody that has an opportunity post today to be able to be involved in sort of negotiation training, it is an essentially important skill for life, but also professionally, because also you're supposed to, when the client does come and knocks on the door and says, I've got this dispute with this person on the other side and they are terrible. It is part of your duty as a lawyer to say, let's see if we can find some sort of settlement. It is your duty not to run to the court or to arbitration. And usually, if you've gone to a lawyer, the other side possibly have gone to a lawyer, you can pick up the phone, call the other side's lawyer. And that happens all the time in our professional lives. You get a call saying, I've got my client, blah, he's fighting with your client, blah. How about we have a conversation, see if we can settle it? And the lawyers sit down and try to find a solution, and often succeed in finding a solution. And the great thing about negotiation, conciliation, mediation, in a way, is that they can continue to run while these things are running. Just because you started arbitration, it doesn't mean it's all over. Just because you ended up in the court, it doesn't mean it's all over. And many courts around the world have now got compulsory mediation. So they force you to actually try to settle your dispute, which I think is extremely, extremely valuable. And people that have gone through those processes with a really good mediator actually speak very highly of it. But I want to put 2 lines underneath a well-trained mediator, because I think that's one of the biggest challenges we face in the region, is that there's a lot of mediation being done. And unfortunately, it is not a licensed profession. So anybody could be a mediator. Anybody can claim to be a mediator and become a mediator and act as a mediator. Also, I think what's really important for most people, mediation is a concept that is very rooted in the culture of this part of the world. And though people think it's actually, everybody knows how to do it. You don't need to be trained. Why do I need to be trained and get certified and go and get any professional certification? No need. I know how to do it. I've seen my grandfather do it. I've seen my great-grandfather do it. This is like something that is so natural for the people of this region and a lot of other regions. But let's just, because we are in this region, we can talk about this region. And I come from this region, so I feel qualified to speak about it. So, and that's part of the challenge that we face, that a lot of parties have found themselves in a room with somebody that thinks they know what mediation is, and they don't. And the experience is not necessarily a positive one. Whenever I do mediation to the room, every time, put your hand up if you've ever done mediation before. Everybody in the room's got their hands up. I was like, wow, really? So what are you doing in the mediation training then? And then it is exactly that conversation that I've just said, where they pick up the phone and they say to their colleague or general counsel of the disputing party, or even the disputing party, is there any chance we can settle this? That's not mediation. Number 2, mediation is not necessarily institutional. So you don't have to belong to an institution. It doesn't have to have an institution. And exactly like, and you can imagine logically, if arbitration, which is a much more formalistic form of dispute resolution, you can do it ad hoc, then you certainly will be able to do mediation ad hoc. And the idea is, and I always like the Arabic word of mediation because it says wasata. And the nice thing about it is it makes you think about a third party standing in the middle between the two disputants. And I think the word in Arabic really is a great indication. When you think about it, it gives you an image of what that person should look like. Now, many laws in the region allow you to have a non-neutral as long as you consent to the non-neutral. But absolutely, taking your point, there is no necessarily any mandatory rules in mediation, the same way as an arbitration. However, confidentiality is a cornerstone of mediation and something that is extremely important. And without it, actually, nobody is going to go to mediation, because you really are supposed to open your cards and share with the other side lots of information about what you want, what you don't want. The mediator tries to do various things about working out what your weaknesses and the strength of your cases. So that process needs to be very well insulated and very confined and confidential, because then you go to court or you go to arbitration, and you don't want that information all of a sudden is actually available to the arbitrator or to the judge. So it's something really, really, really important. Okay, so I think everybody has got a little bit of an idea, and thanks to Christine, this slide turned out to be a lot more fun than I anticipated. And I'm going to use that in my next class. I'm going to find myself somebody in a class, and I'm going to get them to ask the question, because that was brilliant. I really, really enjoyed it. Does anybody have any particular questions about this? We are going to continue talking about the differences between mediation and arbitration and litigation, etc. Do we have a question? Yes, please. Thank you, Nadine.
Yeah, my understanding of conciliation was that same as mediation, but that there might usually be like a judge or someone else appointed and more interventionist.
Is that correct? What do we think? Do you want to ask the question again? I don't think maybe they didn't hear you. Can you say it again?
So my understanding of conciliation and mediation was that the process similar, but in conciliation it's usually like a judge or someone looking for solutions more, so they're more interventionist than a traditional mediator.
What do we think?
I think mostly, from what I understand, it's yes, but said not judge. I think just the difference is within conciliation, they offer solutions more and they get involved, and with mediation, a mediator is not supposed to give you solutions and get involved and just facilitate.
I think there should be an expert in the field who can understand the problem in core specifics that has the problem that has been disputed between the parties. Conciliation is all about having the expert who is specialized in this field, like in our case in the green hydro, and to get the problem solved.
We were doing conciliation in our problem, and you don't need that for mediation. Yes.
So in mediation, like I know the mechanism, then when the mediator asks parties to be together and to negotiate how to tackle the problem, not like win the dispute. Like this is the fact. But in conciliation, the third party, the conciliator, gives the options how to resolve the question here. It's my opinion. And the judge can participate. I search online.
Thanks for the source. Right. So the difference is, okay, let's ask first question. Does a mediator provide the answer? It doesn't provide the answer. So who provides the answer to the problem? The parties. Right? So can you suggest?
No, not really. He can only guide them in order to help them find themselves the mutual ground and mutual beneficial agreement.
Who says yes? Who says yes? Anybody says yes? Yes. It's a legal answer. That's a lawyer's answer. You're going to choose a side.
I would say it depends on the type of mediation. So for certain types of mediation, like for example, facilitative mediation, they're just there to facilitate, but there are certain other types of mediation where the mediator could have some sort of input. They could suggest solutions.
Yes, absolutely. So yes, the form of mediation that I do is facilitative mediation, which I don't. But there are forms of evaluative mediation where the mediator is more involved and could provide opinions. However, that doesn't mean necessarily you're completely to think of what the right word is, that you're not completely involved. And I think it's really just going back to the point about how much you invested. So every arbitrator that sits in an arbitration wouldn't want their award annulled, right? And every mediator that starts a mediation wants the mediation, wants the parties to settle, or at least narrow the differences significantly, right? So you're kind of vested in some way to that process as a professional. But none of those, none of the others aside negotiation, nobody is really hurt by the solution. The negotiation, the parties at the end, whatever the outcome of any of those processes, those are the processes that the parties then have to live with the consequences of those decisions, whether by third parties or by themselves. So yes, absolutely, you're not necessarily involved per se. Yes.
It was connected to that because now I'm confused as to what's the difference between the non-facilitative mediation that she was talking about and conciliation.
So hold on. Are we thinking conciliation is somebody that is making decisions? Is he providing solutions? Yeah. Find solutions, but not.
Is it providing solutions by mediating? That's what I understand. Like you mediate them for.
I think I'm going to I think somebody actually read a definition. I'm going to ask him to read it again. For conciliation.
Conciliation is an alternative dispute resolution where a conciliator offers solutions and proposals on how to resolve the dispute.
You've got the definition. Can he bind the parties to the options?
No, conciliation is a non-binding alternative dispute resolution.
Okay.
It seems to me that we have to make a distinction between two parts. The first is that in conciliation, the party may lead to an agreement. So it is agreement between the parties. But in conciliation, the parties' negotiation may not amount to an agreement. So it is not, let me say, an agreement, conciliation, agreement, conciliation. It seems to me that we have to make a distinction between these two. But in mediation, or we can call it a word, decree, or anything else for the decision that we have to be rendered by the third party.
Of the 3, 1, 2, 3 is the same? Is the product the same? It's not the same? So the product of a successful negotiation, a product of successful conciliation, and a product of successful mediation is not the same. Anybody wants to try? Yes?
I think the product at the end is the same due to the fact that at the end of all of these alternative dispute resolutions, we come to a peaceful agreement by the parties of how to solve the dispute.
Do we agree? We don't agree? What do we? Okay. Do we agree? Yes or no? Hands up. Yes. Yes, sorry, I agree. Hands up if you agree. Yes, I'm sorry, Robbie. Yes, if we agree, please hands up. Okay, so the people that don't disagree, what's the difference? Sorry?
I think for everyone else, it depends.
Depends on what?
Anything.
Yes.
Strictly for conciliation and mediation, I would guess that the conciliator, as my colleague said, provides advice. So this advice could be multiple solutions to the problem, and the conciliator would go, okay, here are your potential solutions. Thank you very much. Bye-bye. Whereas the mediator would issue a report, and this would be, okay, here's what I believe to be the most effective solution for both parties. If you sign it, it becomes binding.
My opinion is that all three result in an agreement between parties. However, for mediation, recently we have seen developments with the Singapore Convention is trying to facilitate enforcement of mediation agreements across borders.
The
there's a clear difference because of the Singapore Convention, it seems to me, but I'm still not sure I understand the distinction between conciliation and mediation, because why does the definition of mediation in the Singapore Convention not fit a lot of the conciliations?
It doesn't.
Does it fit? If conciliation, a process irrespective of the expression used or the basis upon which the process is carried out, whereby parties attempt to reach an amicable settlement of a dispute with assistance of a third person or persons, lacking the authority to impose a solution.
Yes.
Does that describe just mediation, or does that describe also conciliation? I'm not sure. I still don't understand the difference between conciliation and mediation.
Well, the room seems to make a distinction. I feel like I'm being fair of this, that somehow half of the room says it's the same, actually, right? Because the results are the same, it's got third party, they're non-binding, it's the same. And the other half of the room says, no, actually, the results are not the same. And we had somebody explain here that they give a number of options and they leave. And then, I don't know, then the parties decide what to do with those options, which they may take to a mediation, is theoretically, right? Whereas it's slightly different when it comes to a mediation, which there was a report, is what the last version of answer is. Yes, please.
Legally,
we will answer this question, Professor, I promise you.
Legally speaking, if we look at the UNCITRAL model on mediation, at least in the previous version of it, they use the two terms interchangeably. They say it's the same. Conciliation, mediation are the same. However, the only logical distinction I think it is would be that conciliation, the conciliator would try to amend the relationship as it is. Mediation, they could come to a new agreement on different terms. That's the only logical difference between the two, based on the name at least.
Excellent.
If I may just thinking about this, and I'm sorry if I make the things even more complex, I think it's really, now we are reasoning without a legal framework. I mean, we're reasoning in general, but I think it really depends from the legal framework, because now, just reminding, for example, in Italian legal framework, the judge is in many situations obliged to call the party and to try to put the party to have an agreement, and the literal translation will be conciliation. Done by the judge in any moment of the trial, in some situation is compulsory. Of course, it's the same person that then eventually has the power to adjudicate the dispute. Conciliation in this phase will be voluntary, but if parties do not agree with a valid reason, and then the outcome is the one that the judge suggested, the part that they refuse without a valid reason will be punished with damages or a fine and so on. So it has
in the Italian model.
In the Italian model, if
the judge suggests what the answer is.
The judge suggests, let's have for employment dispute. First time they suggest an answer, the employer say no. At the end of the trial, if the outcome is likely the one that the judge suggested to be, not only will have to pay what is, but also have to pay a fine and so on. Okay. I'm making it easy, but it's the judge that is doing this, right? That's the point.
Fair enough. We have the definition in the Singapore Convention. Do we agree? So many of your name. Rada said, actually, the UNCITRAL says there's no difference between them. So how many people in the room agree? Singapore Convention definition, Rada says they are used interchangeably in the UNCITRAL model law. It's every difference between them. Beside the example of the Italians, who call it conciliation. But just because something is called something doesn't make it different from something else. Just because it's called conciliation here and mediation here, if the substance is the same, is it then the same? Yes.
But if you look at their names in different languages, they are somehow the same. Sulh, wasata are not the same. So one is to fix the relationship as it is. The other, it's rather they could come to a completely new agreement on new terms with a new contract, for example, in our case, a new contract based on new terms. And that would be the result of a mediation.
So if they did a conciliation and they end up with a new contract, then it's no longer conciliation, becomes a mediation. Using the words, I guess. Yes?
Bringing in a new question here.
Please do.
does this not change then depending on the cultural factors? Like maybe in Doha, mediation means a certain thing where you can kind of have a bit of influence, but then here in Abu Dhabi, it might mean something else.
And yeah, of course, culture plays a role always, but we are having a discussion about the legal definition of it, I think. And you're absolutely right. And it depends where you are and who is the conciliator/mediator, depending on which process we're talking about, right? Their personality, the kind of style of dispute resolution process that they follow, it might be different, right? Sometimes the parties insist on the third party to actually provide options and solutions. But in my opinion, and I don't think it's necessarily 100% white and 100% black. In my opinion, I think that distinction that existed for a very long time and confused a lot of people with the Singapore Convention, in my opinion, has actually resolved it. If you have two parties with a third party who has no power to impose a decision on that dispute, then it is what now we call mediation. And actually, I think we should call it mediation for two reasons. One, there are now mediation laws all over the world in a lot of the region. We have now the Singapore Convention that actually allows you to enforce mediation agreements. In Bahrain, as an example, fundamentally, if you end up with a settlement agreement that is not part of a process of mediation, in other words, in accordance with the law, which is very important, protects confidentiality, right? And that's really fundamental. The legal framework now exists for mediation. So even though conciliation looks very much like mediation and smells like mediation, and whether they are options put on the table because they are evaluative mediation that allows for that or not, the right answer is to always try to do the process through mediation. And the reason for that is because the legal framework exists. It protects the mediator, it protects the process, it protects the confidentiality. That is on one side. On the other side, which is really important for the parties, is the binding nature of the answer. Is the fact that you can notarize, for example, the settlement and go straight to execution court. And that really makes a huge difference. It's the fact that in cross-border disputes, you are able to use the Singapore Convention to actually to enforce that actual agreement. So it's really good sense that you use mediation. It also, there are recognized, well-established international certification for who could be a mediator. Mediation is also part of many arbitration centers, and there is a service for mediation. So all in all, it is the mediation part of maybe something that grew with time. And there are some conciliator options in many regulated industries where there is an expert. So all the answers you said are not incorrect. There are circumstances in many regulated industries where there are experts that do try to find a settlement between the parties. I don't necessarily see the distinction that if we come up with a different deal, because we often may, then we have left it from conciliation to mediation. But I'll tell you, for example, in a very pragmatic way, in Bahrain, that if you actually manage to get a settlement agreement after a mediation process, then actually you are able to take advantage of refunds in court fees. And that's fundamentally important to the parties, because if you ended up here, and that's my point, that this still can carry on, if you end up here and you actually manage to get a mediator and you manage to settle the dispute out of court, then you have got the advantage of getting a refund on your fees. And that's a really significant point. For me, the fact that mediation have got now established legal structures, it is legally recognizable. And yes, absolutely, like everything, culture comes into it. Culture comes into it, even arbitration and litigation. Anybody that appeared in front of different kinds of arbitrators, common law, civil law, different background, east, west, north, south, right? There are certain characteristics of culture, legal, and even real culture, society culture that comes into every process, because at the end of the day, these processes are manned by human beings. They are people, and that actual culture comes in. So I think there is definitely an element of culture involved. I think also expectations of the parties differs depending on culture. And And I think that's something that's really, really, really important. And a lot of the times you find in mediation in this part of the world that the parties do want the mediator to be involved. They want them to help them with options, even make decisions for them. And it's really, really hard for newly established mediators to resist the urge to answer the question, which seems so obvious to the mediator and so unobvious to the disputing parties and their lawyers. And you always sit there, and I remember my first few mediations going, really, they can't see it? How can they not see it? And I remember my trainer in my head saying, don't say anything. And you hope with the right open-ended questions, and we will continue this process together, and with the right open-ended questions, with the right conversations with the parties, they actually do see it. And actually often, which is really, that's the great magic about it all, they actually come out with a better solution than the one you actually said. And you learn very quickly as a mediator that if you opened your mouth, you will have actually robbed those parties their ability to be innovative and to find the most appropriate solution to their problems. Because as a matter of fact, and no matter how much you think as a lawyer you know this case, and you know the problem, you do not know it half as much as those parties that lived through the whole disputes. And so if anybody is really qualified to come up with an answer to the most effective way to this dispute, for them they can live with and carry on their process, their relationship, whether together or separately, because not all mediation means we continue to the contract. Sometimes we agree that no, we should terminate the contract and move on with our lives, but we do that in a very amicable way that actually comes out with, as much as you can, a win-win situation. And so it's really, that's why facilitative mediation is my choice of mediation. But I have seen colleagues of mine that actually, parties seek them out because they are prepared to do another form of mediation. And it's really, I think, it's a very different experience, I find, when I've actually observed that. Right. Mr. Michael, would you like to share anything with us before we move on to Batna and Watna?
Great. Well, Asil, first and foremost, thank you very much for a very informative, entertaining, involving, all-embracing presentation in relation to alternative dispute resolution and the 5 boxes that you have up there. I think we've covered most of it. One of the things I was going to say was approach it from perhaps another angle and say, who is the decision maker? Who decides in an arbitration? It's the arbitrator. Who decides in litigation? It's the judge. So in those 2 boxes, it's absolutely clear that the ultimate decision maker is not the parties. As Asil was just saying and has been emphasizing throughout, with facilitative mediation, it is the parties who are the decision makers. The mediator is there simply to facilitate, to help to find to help the parties to find their path through everything. And of course, we've covered negotiation. Conciliation is a difficulty. And in a sense, I share Ron's point about not really knowing where conciliation starts and mediation begins. But I think in part, the answer came from the front row on this side of the room, talking about culture. And I think you came back to that, Asil, and I'm very pleased you did, because I think the cultural context is really very important. It's not that long ago that I was talking to a lawyer in the region. I'm going to be deliberately vague, and you will understand why I am being deliberately vague when I tell you the full story. I was talking to him, so I've automatically narrowed the field by 50%. I was talking to him about mediation. And he said, oh, yes, I do a lot of mediation. And he said, but I call it conciliation. And I said, oh, that's very interesting. What's the difference? He said, well, let me tell you what I do in terms of conciliation. I get the papers in, and then I read the papers, and I phone up one side, and I have a chat with them. Half an hour, whatever. And then I phone up the other side, and I have a chat with them. Half an hour, whatever. And then I think about it overnight, and then I phone up the first party, and I say, right, you should settle for by receiving or by paying X. And that's really the end of the conciliation. Now, the reason was that, well, you take into account the stage of the process, you take into account the absence of cost shifting, and the object of this conciliation was to come to a conclusion which could not be bettered in arbitration or litigation. But I must say I found it startling in the way in which it was described as being conciliation. I do say that that was quite a number of years ago, and I think that one thing we've seen in the region is the awareness of true mediation coming on in absolute leaps and bounds. And one sees that particularly in the primary legislation, the laws really across the GCC now, and everyone is very aware of the importance of mediation, what it can do, and not only what it can do, but how you achieve the optimal object from mediation. So, Asil, thank you so much for this introduction. I think everyone is both better informed and wiser.
Thank you very much, Michael. I was just saying to Robbie, we spent so much longer on that slide than I anticipated, but I believe that you understanding the differences and the value of each of those boxes is very, very important. And I also think it actually dealt with a lot of the other things that were coming, but in a much more exciting way. And I think probably lesson for everybody, it's really important that you have agility as a professional. Right? I've set up this training to be done in a particular way, but this conversation got so much better than you could ever imagine. And those are the kind of things you can never anticipate in a room. Now, yes, you can walk into a room and you are very disappointed when everybody's just staring at you and not saying a word. That does happen. Doesn't happen as often anymore, but it does happen. And then you're going to go through the presentation, you go, oh, it was much worse than I even expected. How amazing. However, I thank you. This was really exciting. And I was saying to Robbie, we're going to go a little bit over the scheduled time for this session before we move on to the other part. But I just want to spend a tiny bit of time on Batman What Now, which I know that you guys all know what that is. So I just want you, please, just in case you don't, the first one, BATNA is the best alternative to negotiate agreements. So if we fail in the top part of my boxes, right, what is the best case scenario? And then what is the worst case scenario? In simplistic terms, I would like you to take 3 minutes together to work out in your current Moot problem, what is your what now and what is your BATNA? And I want it for both parties, obviously, so from both sides. So you can prepare one, you can prepare two. I'm happy, and then we can go around the room again where you guys tell me. And really think hard about this. Don't go for the obvious, please. Right? Try to really think. Put yourself in those parties' shoes. You are those parties, the persons, the livelihood, the elected representatives, those people, right? You are there, you've got your heart and soul and your passion, unlike the mediator and the conciliator and the arbitrator and the litigate and the judge, right? You are those people. What is really your worst case alternative and what is your best case alternatives?
Want to split them into little groups or something? Okay, yeah, that's great. That's great.
That was our worst alternative to negotiate agreement. So why would I go with you to mediation? Like, why are you making me? That's why the agreement, I feel like
Thank you. I will definitely, thank you. Yes, I completely forgot about that. Right. Are we ready to come back? No?
Howdy.
Guys, ready to come back? I am so happy you are really engaged in this, and I expect great answers. And I've also been corrected by both the professor and Robbie that one of the jurisdictional questions you have to answer is, the parties did not go to mediation in accordance to the dispute resolution clause. And rightly, if you don't know what mediation is, you can't really argue that point very well. And you can make the argument even better now when you understand what mediation is and what would be the results of mediation, which is very important, very fundamental. The argument that, this will be no better off than what we've just tried to do, which is many days and months and years of negotiation. I hope I've shown you that it's not the same. And actually, almost every mediation that is successful, and the percentage rates of success of mediation around the world is above the 70%. Everybody's tried negotiation before, let's to be clear. Everybody's trying to settle this in some way or another. Brought a professional negotiator, depending on how big the case is, have tried to do it themselves. Their lawyers have tried to do it. They've done it. That doesn't mean they can't find settlement. And actually, the reality is the value, the skills, the abilities of a well-trained mediator to get you to a settlement is actually considerably different experience and process than just negotiation. So I stand corrected. Thank you. So yes, because somebody said we can find arguments to help us in our submission, and I said no, I am wrong. Apparently, lots of things I said could help you in your submission if you use it well. Okay, so who's going to start with the worst alternative? Yes.
So for both positions?
Yes.
Okay. So worst would be for the claimant 15% price reduction in our case. And for the respondent, it would be 0% price reduction.
For the claimant, their worst alternative is that the contract's terminated and they don't get a chance to showcase the effectiveness of their technology. And so they suffer not just a financial loss, but a reputational harm as well.
For the whatnot, for arbitration would be that if they went through arbitration without doing mediation first, it could lead to rendering an unenforceable award. So they would have wasted time doing all of that only to not have an enforceable award.
That was every single nightmare of every arbitration. Yes.
I think that the whatnot for the respondents would be the fact that if they went after mediation, they went to arbitration, and the arbitral award is specific performance, because that is something that the respondents don't want to do. So if it's specific performance at the same cost or even a reduced cost, that would be the worst alternative for the respondent.
Okay. Anybody else? Somebody think a bit? Thank you.
Just slight addition to that, specific performance and also damages to be paid in due to all of the situations.
Can we try to think a little bit more outside? Like, let's just fly a little bit more about reputational damage, the consequences to the claimant of not being able to try this technology. So not very, very different. Can we think about one point on this? Could whatever size amount of damages they could possibly get in an arbitration compensate them for that opportunity? No. So that is huge for the claimant. The worst case scenario for the claimant, if the settlement negotiation fails and or mediation that is actually included in the dispute resolution clause, is actually they win the arbitration. Okay, hooray! It gets enforced, no problem, and they get compensated. but then they don't actually get to try out their technology, which is a bedrock of their business. Yes, please. Thank you.
And then adding to that, if another company comes onto the marketplace and gets that first, then it's curtains for them, right? So it's like this window of time that's crucial.
And that window of time is really crucial even more because they're going to be busy with an arbitration rather than focusing on the price, right?
If I may also add that for respondent, maybe there is the worst alternative is not really that bad. They will simply have to comply with what they wanted to do since the beginning. And how can you see it? They are just giving a shot to get a better price. Leveraging on the fact that they're a big company and they're backed by the government, but they don't really have much to lose from arbitration. That's say.
Okay. Yes, please.
I disagree.
I do disagree with regards to respondent. They do have something to lose because after this new governmental policy, they said they initially wanted 3 projects, and now after the change of policy, they only need 1. And they actually managed to renegotiate one of the 3 already. It's clarified in PO2. So they will, if the result would be specific performance, they will have two running projects. One they actually need, and one that would be completely useless. They would have 2 projects running in the country, while they wouldn't need 2 projects. They only need 1. So what are they going to do with all that energy and all that hydrogen?
Yes.
To add to Ghada's point.
Yeah, please.
To add to Ghada's point, I guess the respondent and claimant can be aligned on one thing, because if we imagine that the outcome of an arbitration where the respondent doesn't get the price reduction they want, and then on top of that, the technology fails. So this looks bad for the respondent because they are spending public money on this project. This is taxpayer money, so it would look really bad for them.
Okay. Yes, please. Yes, please.
I wanted to say, you know, if they have a lot of energy, they can always sell it and make the money and return it to the budget. And it's interesting that, oh, this was a sneeze. Bless you. I thought it was like, oh my God, what did I say? That was so shocking. And it's interesting because, you know, the change of the policy, a policy can change in like 4 years again, or 2-3 years, depending how well it goes. So I don't think that can be a good justification of like abandoning the project that had its own advantages, you know, when the old government was there. So
tell me about it.
Oh.
I kind of am disagreeing in the sense, like, one of the worst things for the respondent, I believe, is the optics of it. It's a newly elected government, and the fact that they'll still have to go through with a project that they were so vehemently against, it looks really bad for the respondent. So that would be one of their what now.
Thank you.
Yeah, additionally, for the respondent, the bad side is the PEM technology is patented by the claimant only, and the respondent cannot get the best solution, the best project anymore. It is like one and only in the market. That's why.
Are we forgetting that the respondent is, you know, a corporation at the end? It's a state-owned company that was making decisions based on what was best on the market, and they have chosen claimant after a tender process. You know, they have chosen that technology because it's its own advantages. And now we are assessing all of this because we have more conservative government, and they don't have big plans for sustainability as the old government was, and when the policy was different. I just think it's like depending on just what the policy is in government, it's a little bit not the smartest and most commercially sensible decision.
Also, the fact that if they do not continue with the project, right, it is at the end gonna look bad. It is bad for their reputation too, because it shows how the power against, like, it's a big company, it's protected by the state versus the small company Green Hydro, and the fact that the mediation or the arbitration has not completed, but they already contacted another company to start the project, so it's gonna give them a bad reputation anyways outside in the professional field.
With regards to the yes, claimant won the tender process. They were selected out of tender process, but they lied their way to win in the tender process. They lied their way to win in the tender process. They they wrote a very well drafted email stating things that stating facts that are not completely accurate.
But not about the technology.
It's not about the technology, but about the purpose of the tender. The purpose of the tender process is because they didn't have a local contractor who could do the project, so they opened the tender process. And their main concern was the local content. They wanted as much local content from Equatoria to promote.
Sorry, it was so important for them that the requirement was only 25%? I don't think so.
That was the bare minimum. 25% was the bare minimum. Claimant only.
Well, yeah. Why don't you think like the respondent is? Why don't you think respondent is just making this? Yeah. Why don't you think the respondent is just making this question of P2G like failing and local content percentages going down? Just a reason to terminate the contract.
P2G as a subcontractor was suggested by our client responded. He wanted that contract to go to P2G, and you promised that it would go to P2G, and then you changed your mind.
I think this is the definition of negotiation. You have answered.
But not the mediation.
What's your name? What's your name? What's your name?
It just shows that we need the mediation.
Nura, just absolutely. I was saying exactly to Robbie. Wow, now we have it live in action, completely unprompted. It's really interesting. Is there anybody else that wanted to say something before we took the mic? Okay, so
Each other's mothers or anything like.
yes. You've got a question or just stretching? Just stretching. Okay. Yes, you have a.
No, but there have been several arguments telling that in the worst case scenario, a respondent will end up with a project that they don't want and they don't need. But on the other hand, even going to mediation, how likely is that the claimant will agree on giving up on the project? So still the respondent will end up with the project, probably maybe with a lesser price.
Which is not bad, isn't it?
Not bad, no, but so from the public opinion, the project will be there.
Yes.
But the reason the respondent actually did get into negotiations with the claimant is that because of the promised local content.
And then they asked for the 15% reduction. If the local content is so important, they were still getting their 25%, right?
Yeah, but do we have any evidence for the local content will go below 25?
Down. This is why
local content. It wasn't just with the bare minimum is 25. We actually went up.
Okay. Wow, this is exciting. Talk about fighting. I love it. I really love it. You know, clearly everybody. Okay, so hold on. Can we just like go back to the question? So because well, I'm really happy that we've ignited fire under you and you feel so strongly about this. But this is negotiation at best, and usually it looks like that. Like we look, and actually quite a lot of mediation also look like that, and with somebody in the middle trying to find some sort of peace among the parties, which we will see. But I wanted to, okay, so we spend a lot of time on the worst case scenario. What is the best case scenario for the parties, briefly? Is the claimant specific performance? Yes, no? Yes? Is for the claimant, no?
I would say something in the middle, 3% price reduction, and the agreement, best case scenario.
A specific performance with a price reduction
yes.
is best for both parties.
Yes.
Right?
Yes.
Is that your answer?
Yeah.
So,
yeah, reasonable. Like
what's reasonable?
Reasonable, like alternative to what's what they have.
So it's not. I love it. Right. So is the reasonable alternative? Do we think it's a win-win situation if the claimant gets specific performance and the respondent gets 3% number reduction on the price? Right, hold on. I'm coming to you. Yes, please. Yes, please.
I don't.
My understanding,
Yes, no, I don't think so because I think there should be no price reduction, just specific performance, according to the claimant. Yeah, yeah.
yeah, but like my understanding is that we are discussing what can happen without any agreement if the arbitral tribunal decide the dispute, correct? This is like the best and worst situation, yeah. So, yeah, for mediation. So basically, for respondent, it will be to declare that the PSA should be terminated and the project will not happen. So there is not a request for price reduction in front of the arbitral tribunal. That's my understanding.
Yes, please.
I think another best case for claimants would be that they also get compensated for all of the delays that respondent put, or for terminating the contract and not using the best endeavors.
To your question, probably yes, it would be satisfactory for both parties because if we remember, the respondent is reporting to the minister. So at least in that scenario, they're going to go back to the minister and tell him, hey, we got you a price reduction like you asked. And then the claimant will still have the opportunity to portray their product. And they were already willing to go into this as at a loss in the first place.
Yes.
Well, I just wanted to say quickly that I think the respondent best case scenario would actually be to get the plant. I mean, disagreeing with my learned colleague. Oh, okay. I'm sorry. Misunderstood. Yeah. Yeah. Okay. Yeah. Right, but I think they both want the agreement. They both want the agreement to continue, but respondent wants to end up with the.
Wait. Let me finish the sentence.
Well, the respondent wants to. I think they want to end up with the plant. It would be very advantageous for them to end up with the plant. So I think that would be a best case outcome.
Okay.
Okay.
All right. Yeah, I take so can we just be clear? Yes, you're saying that's not even before the tribunal.
Up with the plant with the discount is not an alternative to negotiated agreement. Is a negotiated agreement. Okay. Because as the thing stands.
Yeah.
So it is a win-win, but you need an agreement. You need a mediation for that.
Absolutely. Right. Yes, absolutely. So we start. You're absolutely right. So there is for the best case scenario for the respondent is this is something of the past and we can all forget about it and move on with our lives. And they've never done their promise and all's good, right? And they can make a big media hoo-ha about it. Absolutely. I agree. And then I built up on the question is what would be a win-win for them? And that's what everybody else were then answering me. But you're absolutely right. You were answering the first point. And do we all agree for the respondent, the best case scenario is termination of the contract? No? Yes? And then Nadine? Yes?
Well,
Yes,
yeah, go ahead.
go.
So when you think about it, if we look at the respondent as a state-owned company and the fact that this state-owned company just pulled out of a contract because of a policy change, that's not a good look for the participants of the international market. It's not really a good reputation for a country to suddenly change its policies and then completely pull out of contracts on investors, etc. So it's all about their reputation. Oh yeah. Sorry. But yeah, I mean, all the countries in the global market have reputations. And if that country's reputation is not good, if their reputation is that they don't uphold their contracts, then nobody's going to want and go and invest in there.
Yeah. Yes. Can I say we are mixing all the time respondent, who is the entity, with their government. And I think what I wanted to add, the best case scenario or best alternative to negotiated agreement for the claimant would be to have some kind of mechanism that the government does not impact the business of the respondent, the entity, like have some kind of separation, like I know they're state-owned, but not every state-owned company functions the way the respondent does, you know.
I think another best case scenario would be to reduce the size of the plant, and that could cover the price reduction that respondent wants.
Right. Okay. So we've heard a number of possible scenarios that could be best case and worst case. We've had these, but we also had possible solutions that could be reached by the parties through a mediation, and that's why we want to do that. So I want to show you very, very quickly. Actually, no, I'm not going to show you that because now we're going to do it live. If we had time, I would have showed it to you. I can send you the link. It's a role play of a real mediation. And actually, it's funny. It's very close. The dispute is very close to our current dispute. It's really interesting. So I'll share it with Robbie. He can share it with you because I'm conscious of time. But just want to end very, very quickly on very quick points. When we are actually going through a mediation, what we are actually trying to do is separate the position, identify the positions, the interests, and the needs of the parties. And I want you, as I speak, think about for each of. We were going to do an exercise, but I'm really conscious of the time now, and I don't want you to miss out on the mock mediation. So think about, as you hear the parties doing the mediation, and you as the audience will be involved in this. So you will be asked to think about what is the position, interests, and needs of each of the parties to help the mediating parties come to a settlement. And so the position is what they say that they want, which is very well made by our friend over there who said, in the request for arbitration, it's very clear they don't want this plant, right? That's their position. And actually what's really interesting is all the other discussions that came up is actually what their interests are and what their needs are in reality. So they say they don't want this. But the question is, do they really not want this? And that's exactly where a mediator actually finds amicable settlement. It's when they get behind the position and find out really what the needs and the interests of the parties and then align it for a win-win situation. And we're going to witness that together in here. But I want you to think as we set up and as we go through the process of getting everybody set up for our mock mediation is what is the parties' positions, interests, and needs. And very quickly, I just want to share with you as lawyers. Now we go to the point where when you as a lawyer, what do you do? And I'm going to do this very, very fast. But I want you to note, in Dubai this year, they actually made mediation representation / advocacy compulsory for every single lawyer licensed in Dubai. So now you as a lawyer is required by Dubai licensing authority to actually know how to support your client during a mediation process. And that is actually not an easy task, and it requires special skills, and you need to be very conscious of what a mediation is, which now we all know what it is, so you can actually advise your client on how to prepare for it. And that does involve a process of making sure that the case is fit for mediation, because the worst thing you can do is go to a mediation with a case that really wouldn't work and the client really gets just an unfortunate experience. Choosing the mediator is extremely important, and then initiating the process and agreeing with the other side. Obviously, like in our problem, if you have a mediation clause in your problem, then 3/4 of the problem of the start is done because it's part of the dispute resolution process. However, there are often situations that is not, and if it isn't, then you're still able to agree with the other side going to mediation and initiating the mediation process. And then you need to help the mediator, and we're going to see our learned friends today helping and not helping and challenging the mediator in this process to coming to an amicable settlement. Navigating challenges during mediation, right? Trying to help your client really see what is his batna and what's his watna, and what actually could he really gain from a settlement. And finally, and most importantly, is drafting. and there's something very, very important. The parties draft their settlement agreement with their lawyers. The lawyers will draft, and that's a very important role for a lawyer to ensure that that settlement agreement is in line with the legal framework, because a mediator might not be a lawyer. It's in line with the legal framework. It is enforceable. It's notarized if it needs notarized. The right authorized signatories are signed it, and something essential and very important, you don't let them leave without them signing, because at the moment they do leave, there is a very high chance they're not going to sign. And that does mean sometimes settlement agreement. You know, you always hear about arbitration clauses being the midnight clause. They are even more like the early hours of the morning settlement agreements, but you need to make sure they sign before they go anywhere. Just going to end really quickly about what are the targets for everybody in a mediation. So for the mediator, it's to attain the mandate to mediate. It's very important that they have the consent, the agreement of the parties to mediate. They conduct a conflict analysis for them to understand. My friend Michael, who's going to be doing our mediation, who's going to be the lead mediator in today's problem with our team, has spent the last couple of hours analyzing this problem very deeply, because I just told him this afternoon. So, you know, well done, Michael, for agreeing to do this. Try to engage the parties, because sometimes you find yourself literally parties just sitting there going, I'm not interested. I'm just here to jump through this hoop and leave. So trying to engage the parties is really, really important. Logistics are really important. Water, bathroom, really. Food, I find food is a brilliant way of getting a settlement. And whenever I get a bit of a good, you know, a bit of a deadlock, I actually say, how about we take a break, have some coffee. And all of a sudden, people start being people, right? They're no longer sitting across the table from each other. And then, you know, maybe sharing a croissant or chocolate. Sweets are always good. You know, that is really helpful. At the end, there was a very funny story about a mediation that was done by a very ministers of justice ago in Bahrain, who was a very famous guy that did a lot of mediation, and we locked the parties in the room and we didn't let them leave until they actually settled, but provided them with lots of food to actually you know, fuel them through the process. But it's really important that you actually do have these things. And, you know, walking there, you don't know how long it's going to take. Most mediations take about a day or two, but you need to make sure that people are fed. If people are hungry, they're going to start. Nobody's saying anything. Even though somebody said to me, people are hungry, they might settle real quicker because they want to go home and have lunch. I don't know. It depends who the parties are. And you help assess the participant reaching the final stage, which is the settlement or the narrowing. Even if they don't settle all of the dispute, they could narrow a lot of the dispute, have some agreed terms, issues of agreement, and then issues of disagreement that could then go further to arbitration or litigation. The lawyers and the parties need to understand the process, and this is the role of the lawyer is so important, to explain to the parties that have never been through a mediation what a mediation is, what's expected of them, what should they expect. It is always very frightening for anyone to go through a process they don't know what's happening. So it's really important for a lawyer to explain to the parties what is going on. It's important for them to try to address sometimes power imbalances, big company, small company, maybe you have a situation where the claimant walks in with one person, the respondent walks in with an army of human beings, and that's very scary, right? So those kind of things, it's really important, and you work with your client and the mediator to come up with a settlement as much as possible, and everybody at the end feels very, very empowered. I am just going to end with clients. You need to explain what the process is, what the principles, what's going to happen. You need to give them a reality check, really, really important, right? And Michael gave an example the other day when you have told the client the weaknesses of their case, and then the media walks in, and you'll see Michael do that to the parties today. And then the lawyer goes, I told you. And so that's very powerful. So you can have real good help from the mediator on that. Identifying the client's priorities, having great communication, and then initiating the mediation. And we are going to do a mediation now, and I will share some of these slides with Robbie about I'm going to leave that in the background so you can think about it as we go along. It is what are the many different roles that a mediator has a lawyer have in a mediation process. So when we get the parties and their lawyers to the
Quickly, let's get on down
Do you have
and
a
get this
question?
started. Come on, let's go.
You have a question? Can you ask a question as Did you want?
Let's go.
No, they right, let's go.
Remember to talk into the microphone so it can be in the recording.
I hope you enjoyed that. Everybody? Everybody enjoyed that? Thank you. I wasn't looking for applause. I was just making sure that everybody enjoyed that. Can we think through position needs so we can help these guys come up with a settlement? Michael, the floor is yours.
Great. Asil, thank you so much. And what I want to do is deconstruct a process of mediation slightly, because what you've seen is I've drawn in two flip charts. And in an ordinary, in a mediation, you would have these in the parties' separate rooms. And you would do a lot of work on the flip chart in the caucus with each individual party. Now, we can't obviously do that for today's purposes, so I'm going to take that part of the mediation process and bring it forward, because what I really want to do is bottle some of the secret sauce that Asil has already been cooking up in the room. Because what you want to be doing with the flip chart in an early course in a mediation is working out priorities and pitfalls, positive interests and negative interests. Now, that's going to be informed by the Batner and Wapner. So what we're seeing now is, if you like, a direct consequence of what we've been talking about. But ordinarily, you would only get to the flip charts after you've had the introduction, after the parties have had an opportunity, a very short opportunity, to present their case and whatever is at the forefront of their mind. We'll see that in due course, but at that stage and throughout the course of the mediation, the real skill of the mediator is active listening. We'll see, I don't, none of this is rehearsed, so I have no idea what is going to go on. And that again reflects a true mediation. So a mediator has to be ready and flexible and adaptable to whatever is thrown at him or her. So it's quite an exciting day. It's a long day. But going back to capturing the source, let me see. We've got a couple of pens here. And let's start off with the claimants here, respondents here. So before we start the mediation itself, what are the priorities? We've already covered this, but what are the priorities? We'll write them up on the flip chart. What are the priorities for the claimant, first of all? Yes. Get their products out. Product to market. Anything else?
Y'all were going to kill each other 10 minutes ago.
Yes. Is that the be-all and end-all of... Well, let's go. All right, let's move over to the respondent. What are the respondent's priorities? We've already... Yes.
Cheaper energy, I would say.
So we've got a macro point there. What about the micro points? Perhaps going... Yes, sorry.
Well, maybe along those lines, a viable green energy strategy for the future.
And just pausing there, what is the important word that I've just written up? Because, of course, there was a green energy strategy. So we've got political considerations, we've got political overtones, all matched up in that word viable. Other priorities and
for Clement, I would also point out the time frame. So not only the product on the market, but only in a short time timeline. So time is important.
First mover advantage.
So
first mover advantage. Yes, getting to market first, getting the advantage of doing so.
I think also for claimant, they would probably like a fair price for their product.
Anybody else?
Well, let's just pause on fair price, because there are some interesting sub aspects to, sorry, who said fair price?
Over there.
Oh, yes, there are some very interesting things in relation to fair price. Because was the claimant actually going to make a profit out of this contract?
No.
So we're into very nuanced territory in relation to price.
So at the very least, they wouldn't get the extra 15% discount that they were asking for on top of not gaining any profit.
So you're looking at how at playing around with the 15% discount.
Mm.
Okay, so we're getting a few priorities here. We're getting some priorities here. Any more priorities for either of the parties? What are the pitfalls? What do they really want to avoid? Again. Yes.
I think for claimant, they want to avoid that the contract is actually terminated because they want their product on the market.
So the flip side of getting the product to market is avoid termination. Any other points, pitfalls? What do you want to avoid?
I would say another priority for the respondent is for them to keep their jobs, because if the project ends, there's a likelihood that they'll be dissolved.
The respondent keeping their jobs. So what you reduce the work which is being undertaken by ECREN Power, and there will be redundancies and layoffs and whatever.
And correspondent, what they want to avoid. I will keep this general because I hope that you can help me to better frame it. But they won't, no, really, because they want to avoid to lose the face in front of, the society and political party, which either means to not have the plant at all or to keep it, but being able to say, hey, we got an additional discount, or maybe we lower down the capacity because we don't believe enough in this energy. So to have something that avoid that they totally get a political backlash out of this.
So there's face saving in terms of the political environment. There's perhaps face saving and more acute issues internally. So we've got internal and external elements at play. We got a good list. Anyone? Yes.
Can you just please extend on the point of keeping jobs?
Yeah, I don't think that's
it
doesn't
make
sense at all. And that's an issue for the claimant.
Yes,
Well,
because
that's why I asked for clarification in that regard. It could be, okay, let's take your point. It could cut both ways, because if the claimant loses out on the contract, if the contract is terminated, then what is the impact on the claimant's workforce? a big contract which was going to take place. It had time pressures not now taking place. Does that have consequences for the claimant? So we may be able to put the same point over here. So let's put it in. It's really the effect of termination. Okay, and your concern is there a real issue here because it's a government state-owned enterprise and the government would just keep people on the pay books, on the payroll, because they want to avoid unemployment, even if they've not got a job to do?
Go ahead, do you want to explain your?
Sorry, yes.
Yeah, go ahead. No, it's on.
I think we're thinking of the, there is there is local content. So there are people who are Equatorianians who will lose their jobs if the project ends. But I agree.
Okay.
Also on the claimant side, this
Right.
is the
So we've got local content. And that has political,
Okay.
dotted line into politics and a dotted line into the wider social implications.
I wanted to add something about this political. I don't think that's going to be something that the respondent is too worried about, having in mind their actions so far. They're ready to initiate investigations and put people in prison.
Yeah.
They already were cutting down the jobs as soon as there was a change in policy and change of the government. So I don't think that those going to be the things that keep them motivated or scared of, what's going to happen.
Okay, let's just park that for the time being. Let's put a ring round politics and take it down lower priority as you see it.
And additionally, there's 2 more points.
Yeah.
As claimants here, as claimant holds the patents for the PEM technology, the respondent wouldn't be able to find the alternative. And they have a policy for ecological strengthening role of the eco-friendly technologies by 2030. So this policy, really big policy, would be not hypothetically wouldn't be able to be finished.
Okay, look, I'm running out of space on my flip chart. That's probably because of my untidy writing rather than that I've exhausted all of the points that could be put up there. But we are running against time, so I'm going to pause it there.
Actually,
there was
yes,
one at the back, and I always miss out the people at the back. Okay.
Okay, actually, I wanted to add for the respondent side. What about the investment climate?
The investment climate.
Yes, I think that is very important in this.
Foreign direct investment and whether you are an open, welcoming front door or whether you've got a couple of Alsatian dogs at the door fending off anyone who wants to come in and invest in the country. Yep. Okay, now that is, as I say, that's anticipating something that would happen in the course of the mediation. Let's turn to the mediation. And we are now meeting in the general session. So first of all, let me introduce myself. My name is Michael Patrick Joyce. I am your mediator today, and we are going to try, with my help, but it's your objective, we're going to try today to see if we can reach agreement or we can find some common ground in relation to the dispute between you. Now, before I proceed further, it's going to help me if you can just introduce yourselves and tell me who is, I think you've both got mediation representation. So who is the client, who are the lawyers, who you're acting on behalf of?
Hello, my name is Ms. Teresa Vent. I am the Minister of Energy and I'm the Minister of Energy of Equatoriano.
I'm Henry Lacour. I'm the CEO for Equatorial Rent Power.
Hi, I'm Julia Fast Track, and I will be representing my clients.
Hi, I'm Mr. Smith, and I will be representing my client, Green Hydro.
Hello, I'm August Damon, which will be referred to as Mr. Damon, and I'm the head contracting.
Hello, I'm Miss Cavendish, and I'm claimant's CEO.
Great. Thank you all very much. That's very helpful in terms of knowing who is who. And let me now tell you what I know about the dispute. Obviously, I've received the papers, I've read the papers, and as I understand it, green hydrogen, you are a specialist in engineering and in the planning and the development of green hydrogen plants, including all sorts of commercial services which are associated with that. Equatoriana Ren Power, sometimes known as EREN Power. You are a government state-owned enterprise, and you are responsible for implementing the green energy strategy in Equatoriana. But I'm aware that there has been a recent change of political administration, and that therefore you have terminated the contract. That's what I have learnt from reading the papers. The purpose of today is to look and see whether we can establish common interests and focus on interests rather than rights. I know that you have an arbitration ongoing. The object of that is to focus on rights. Today, we're going to look at interests. As I say, the object of today is for me to facilitate you in seeking to find common ground in terms of settlement. In many respects, this is really your last opportunity before the matter goes headlong into arbitration. And although there is the concept of party autonomy in arbitration, the ultimate decision maker is the arbitrator or the panel of arbitrators. Today, you jointly, collectively have an opportunity together to look and see whether there is an alternative. I should say that arbitration, just as litigation, can be binary. There is very little, if any, room for flexibility, whereas in the context of a mediation, there is much greater scope for flexibility according to the parties' needs. I am not a judge. I am not an arbitrator. I have no decision-making powers. I am simply here to help you reach whatever agreement or common ground you can. So let me make two further points. In terms of the course of today, shortly I'll invite you both to make very short 2, 3, 4 minute presentations of your case. You can rely on the fact that I've read the papers, so it's really in supplement of that. The value of working together is that everyone can hear what everyone else says, but at various points, quite early on perhaps, it will be more useful for us to break into separate rooms, into separate caucuses, when I can talk to each of the parties and explore some of the priorities that we've already, or in the course of the opening, been able to reduce onto writing. That is not something which is fixed. You can add to, you can subtract, you can move things in terms of priorities. So I'll speak to both parties separately. There is nothing to be read into who I start with. There is no predisposition. Either way, it's simply, probably from what you say to me in the next few minutes, that I'll decide how we go into caucus. The final thing that I should say is confidentiality. Mediation is entirely confidential, and that confidentiality works two ways. In the course of the mediation, anything that either party says to me in the privacy of the caucus room remains private between us until such time as you authorize me to take any point or offer to the other side. So I only act on your authority in that context. The other aspect of mediation is that anything said in the course of the mediation cannot be used outside of the mediation, and therefore anything which is shared today cannot, if you fail to reach agreement today, be used subsequently. So that's what I would say by way of introduction, and it may be convenient first if I call upon the claimant to claimant to have just 2 or 3 minutes supplementing what I've read in the papers in explaining your case.
Green Hydro, a leader in innovative green hydrogen technologies, are here today to seek a fair resolution to this dispute concerning the purchase and service agreement signed with Equatorial Run Power Limited, dated on 17th July 2023. Green Hydro has always been committed to advancing green energy solutions, and this project was pivotal not only for us, but for global environmental goals. We entered this agreement in good faith, expecting to partner with Equatorial Run Power to achieve something remarkable for the energy sector. Unfortunately, after diligently complying with all preliminary requirements and investing substantial resources, we were blindsided by a change in governmental policy and management at Equatorial Run Power. This led to the termination of our contract by the respondent, dated on the 29th of February 2024. Citing policy shifts and supposed delays on our part as their rationale. In addition, regarding the delays in the project's timeline, they were minor and within reasonable bounds of such large-scale projects. Moreover, these were communicated transparently and in a timely manner. Despite these hurdles, we still continue to exceed the contractual local content requirement. The sudden termination of the contract has not only put our investment at risk, but also threatened to stifle innovations and tarnish the potential for green energy advancements. Therefore, this outcome is not just a setback for green hydro, but a significant blow to global environmental efforts. And to add to that, our employees and CEO were arrested unwarrantedly, which not only damaged operational capabilities, but also the morale and the welfare of our team, who dedicated so much in continuing and focusing on this project. Thank you.
Councillor, thank you very much. Council for the respondent as well.
We unfortunately are here today due to Green Hydro's failure to uphold the most basic contractual obligations. That is delivery on time and in full. The late delivery and the lack of the e-ammonia option, contrary to what they might say, disrupted my client's planning and issuance for the permits which were necessary for the construction of the plant. Even if the late delivery did not impact the project's realization, their failure to include the e-ammonia option certainly does. This is because if my clients had not terminated the contract and held out on green hydrogen, we would have had to wait for another plan once they resolved their issues with the company Green Ammonia. Or we would have had to find a new contractor for the e-ammonia option altogether. Either way, both would have taken an unacceptable long amount of time. Considering all this, my client's termination is a rightful exercise of their contractual right to terminate. This termination is also justified for convenience. As a government entity, my client's obligations extend beyond just being contractual. Their first and primary duty is to its country and to its people. That's why any waiver is certainly conditional on compliance with public policies, which is consistently evolving as it is in Equatoriano. Finally, considering all this, my clients still acted in good faith by offering Green Hydro another chance to fix their mistakes with a 15% offer. We also allowed them an additional 28 days after the day of delivery before actually terminating. And finally, we are here sitting, offering Green Hydro yet another chance to fix their mistakes and find a sensible solution. My clients and I seek a settlement that reflects their breaches and our rights as a government entity.
Thank you very much, Council. Now, I think that it's probably sensible for me to begin by talking to the claimants first, to talk to Green Hydro about what they've said and what they've heard in the course of this opening. So how are we going to do this? Are we going to... Then that side, right, okay.
Think about sides sounds scary.
Yeah. So you stay put. So what did you think about what you just heard?
Complete nonsense. Complete and utter nonsense.
Let's take it in stages. Why? What's nonsense about it?
Giving me 3 chances, another chance, and another chance. Does that actually make sense? I've given them more than enough. I've got into this contract on a loss basis, and they're giving me another chance. Does that make sense?
Well, if there is a real other chance, then it might make sense.
I'm already on a loss.
Yes, you're on a loss, but at the moment the contract has been terminated. So, what are your interests? What are your priorities here?
On what basis is the contract terminated?
Well, they have terminated the contract. You are bringing the arbitration in relation to your rights under the contract. But is there a way that one can look at finding some way through this?
So they have actually not had a valid termination. To give me a notification that it's been not terminated is not actually terminating the contract. It has to go through a process. So even that demand is not really.
So if we worked and looked at whether there has been a termination, if we get to a point where there is movement and continuity, what you would be looking for movement and continuity in relation to the plant or the options? Talk me through that.
If I may, as going through this contract itself had put us into so many unfortunate circumstances. As me, myself, I was actually detained and put into prison for some kind of things that I didn't even believe that would happen. Going into a contract such as this would really put you into jail. And for the demands that they were asking for, the crazy price demands and reductions. Moreover, also to the, just because of the saying or stating that there was a government policy change, or even to the delay of some kind of things. But isn't it this part of the contract, isn't going into a contract and negotiation kind of puts someone into this kind of thing? Would this still put me into jail?
Now, if the jail risk is put into play, then how would you retrieve the situation in relation to the contract at all? Because you would need to be visiting and going there in order for the contract to be put back into operation, for it to be revived. And if the interest of Green Hydro is actually to see some form of plant constructed, then surely we're going to have to work through your primary need for the plant to be, the contract to be revived and some form of plant to be installed, and the security, the personal integrity that you've raised as a very valid issue. Are we looking at a dynamic there where the positive is a reinstatement of the contract, but with corresponding security as far as you and your colleagues are concerned?
We have more demands.
Okay, that's not the full picture, but is what I've said part of the picture?
Yes.
Okay. So what are the further demands? Paint the further picture for me.
Our company's integrity has been violated. The media coverage in which we appeared in the worst case scenario. We have an image to like appear to. We have new technologies to want to. We have new partnerships we're looking forward to. None of these. This media coverage has ruined us. We're already losing a lot of money. We're already losing a lot of time, and also our reputation is at stake. They have to apologize publicly to me and to my employee.
If I may, there are three main priorities that we want to fulfill in this mediation session. The first being the fulfillment of the agreement under the purchase and service agreement. The second being to allow Green Hydro to start construction works. And the third being to continue with the payment schedule. However, we do also have a lot of major priorities and non-priorities that we want to implement in these sessions. As my CEO said, we want a public apology for Mr. Damon and a statement to how Exhibit R3 was procured, which was illegal and violated my client and his employees' rights.
So can I just explore a little bit more detail what you just said, Council? You started off by saying that you were looking for, Green Hydro is looking for the fulfillment of the agreement. The agreement is comprised of the plant with connected services, but also options. Are you looking simply for the basic contract to be fulfilled, or how insistent or otherwise would you be on the options?
We are willing to delay the project by 2027 if that makes the respondent more eager to continue this project's continuation. However, we want to continue the project as stated, as it was terminated wrongfully and with no apparent reason.
But as I understand it, what you're really looking for through the fulfillment of the agreement is a working operative green hydrogen plant having been established, so that it's a proof of concept aspect where you want to prove that the research which you've done and which you believe on a modeling basis works would actually work when scaled up. Is that the essence of what you're looking for?
Absolutely.
And can that essence be achieved by simply constructing the 100 megawatt plant without the additional options to extend, without the option for e-ammonia production?
It can, yes, but we have lost so much already.
And obviously you say starting construction, so that is getting on with it quickly is very important for you. And in relation to the payment schedule, then I think the payment in the contract is on the basis of including the options.
Yes.
So if one's looking simply at a proof of concept, and something which is less than is included in the full contract, then you would be happy to, or you would accept the need to renegotiate the price which presently is for plant plus both options.
Yes.
And then in addition to that, there is the two aspects of reputational loss: the personal affront, as you see it, to what happened as far as you personally were concerned. But I think you also raised the reputational loss for which you would also seek an apology.
Both me, myself, and the whole company were actually very severely affected. Going into this contract was just so badly, just keeps going downhill, we would say, as based on just me being detained and imprisoned for fraud and misrepresentation, as well as for the project and for the name of the company itself to all be at risk. And just itself, we're already losing so much.
Sorry, you said that the company was going downhill. Could you expand on that?
As when I say the company is going downhill, I'm speaking about the name. How people are now perceiving us just because of the things that are portrayed through the news, the internet, how everybody sees us right now, just because of all the unfortunate circumstances that are going right now. It just doesn't make any sense for people to perceive us that way. We were just like any other company trying to go into negotiation and sign a contract with another company, but did never expect for the circumstances to turn out that way.
This is not our first time contracting with the government. We've already done multiple contracts with multiple governments. None of this has ever happened before. This is unreasonable. We don't want this to happen again. We want this to continue as a normal contract.
Now, I'm already beginning to get ideas about what are your prime priorities and motivations. What I'd like to do is talk to the other side similarly about their response to what they heard in the introduction, and then I'll think about, aggregate by combining what I hear from both parties to see whether there's a way forward. I'll come back to you in due course. Thank you so much. Yes, you have to leave.
I think we need to remind the claimants again about confidentiality. I think back here. This question.
Okay, these are the mics. We have 3 mics, guys. 3 mics. Right.
So you heard what the claimant had to say. What did you think about what you've heard?
Lies, all lies. I didn't believe anything they're saying. They kept blaming the government. We have the Minister of Energy here, so it's completely unreasonable that they would say things like that. I don't think we're going to get to a settlement today. To be honest, the only reason we came here is because we wanted to protect the jobs of Ecotran and workers involved in this. We know that the claimants are only doing this for their marketing purposes or whatever, but we wanted green energy and we wanted to supplement Ecotranian businesses, which is why the local content was so important to us. And still, they didn't do it. They got green ammonia from Danube of all places, and they didn't go with P2G, some place that we recommended. So we're just beyond disappointed. I personally don't see the point of all of this.
We're here for the Equatorianian people. The Equatorian people have lost faith. They're literally bashing them in our news. So why would we want to continue working with them?
Now, let me just look at what you've both been saying, and you obviously feel very passionately about the circumstances. But first and foremost, even though there's been a change in strategy, you were saying that you, as a country and as a company, want green energy.
So essentially, our stance is that we do want forms of green energy that are cheaper. That is why we went forward with another plant, which is for 50 megawatts with the alkaline process. So instead of green hydro, we went forward with them and they gave us a price reduction as well. Very reasonable people, unlike the claimants.
Now, before we move on from that, in terms of cheapness, it's a matter for you, obviously, as to what are the demands of Equatoriana, what are the growing energy needs in Equatoriana. The base plant without additions here was 100 megawatts. And with the capacity that you've described is only 50 megawatts. The option was going to take it up to, I think, double capacity to 200. So that, in fact, what you have now is a quarter of that which was the demand predicted under the previous green energy strategy. Now, from the company's perspective and in terms of the company talking to government, is that really going to be enough as the demands of green energy in particular, renewables, grows?
I think with the other projects as well, we might consider an extension option. And even if we had to look back at green hydro and to continue with the project, I think we would have some demands, and we've communicated this within us, and we believe that if we're going forward with green hydro, we need a price reduction. It's too expensive for a project that's not even realistic or commercially feasible.
Can I, again, just test that a little bit? Because don't we, as I understand it, the energy is going to be expensive. So one needs to look at comparables. And from the papers that I've read, the green hydro, the PEM electrolyzer, had an 85% efficiency rate, which seems to be a pretty high efficiency rate. So efficiency surely translates into relative cost effectiveness.
Yes, I understand, but we also have our traditional methods of energy, which are still clean and still cheaper. So it just makes sense for us to do that now. So if anything, to consider this and sense of cost efficiency as well, they've already created such a significant delay. By this time in the contract, we should be starting to get ready for the test run, but here we are in mediation. So it just does not make sense for us to continue this unless we rewrite some of the terms of the contract, starting with the contract price, and then seeing if they can give us a demand guarantee. Also, another thing from our government's perspective is the optics of it. So in case we have to continue the project, we want them to conduct a feasibility study or do some research to show that this is still viable, so that we can assure the Equatorian people as well that it's not a waste of money, it's not a waste of time.
So
exactly. Sorry to add on to her point. Exactly. The Equatorian people, they need to be 100% on board with this, because why are we here? It's a government. We're here for our people. We're not going to be here discussing this for nothing.
So if you got reassurance in relation to efficiency translating into cost efficiency, so value for money, which is obviously very important for the Equatoriana people. And that, of course, value for money would also support Equatoriana business. That for you is a very high priority, as I understand it. And you've put forward a very constructive way in which that high priority may be looked at, which would be a feasibility study in relation to ongoing viability, both of the plant particularly, and perhaps also the options. What is it the plant, or is it the plant plus options that you're interested in?
For us right now, it is the plant plus options. And there is another thing that we were considering as well. If we're going forward with this project, we don't want to be involved with green ammonia anymore. Even though they're a third party, they're a party that they've subcontracted that cannot deliver on time. So we don't want green ammonia. We want the claimants to contract someone like P2G or P2G itself. So unless these demands are met, we're walking out.
Now, earlier in what you were saying, you were talking about the possibility of an extension option. We've already identified that as compared with the original green energy strategy, there is a reduction in green energy coming into the Equatoriana grid. What is the speed? How quickly do you feel, in terms of supporting Equatoriana businesses and in terms of being fair to the Equatoriana people, how quickly do you need to get more capacity in green energy on board?
So even though the previous strategy was for 2040, we are reviewing that strategy consistently now. So why right now time is still of the essence. The contract was supposed to materialize by 2026, but I think unfortunately with the way that things are going, we might extend it in case of specific performance to 2027, but that is at the latest.
Now, going back to your reluctance for green ammonia to be involved and your preference for P2G, I can see why you say that, but can we put that against the time constraints? Because even if it's an extension of a year, it's really only an extension of a year within the new policy. So there will still be time constraints where you need to get a green energy policy in place.
I understand, but the reason that we're still pushing for a change in the supplier is because to this day, we've never seen the final plans with the e-ammonia option. And that is because they're still contracting with green ammonia. So I just think, well, the company thinks that it's better to go forward with a local supplier as well. That way they can boost up their local content like they promised us on 10 July, but regardless. So we can still go ahead with a local supplier and we can maybe get more assurances for the timely delivery of the plant.
And from your perspective as a state-owned enterprise in Equatoriana, do you have confidence that either P2G or there are other suppliers for e-ammonia which perhaps haven't been identified previously?
I definitely think that there will be. With P2G itself, they told us that any quality issues that we were never aware of before, but they told us that those quality issues could have been overcome. So I definitely think that P2G or any other companies are still viable options for the claimant to consider.
Yeah, you say the other suppliers will be available. Now that is future tense, and therefore what time frame, again, given the importance against the policy objectives, what time frame would it take for new suppliers in Equatoriana to come on board?
We need to discuss. Not an easy decision to make easily, because first of all, we have reiterated several times that we need the local content to be a greater amount than 25%, 25% or above. They have met the 25%, sure, but they didn't do it. Why didn't they do it with P2G? Why go all the way to Danubia?
Well, what I'm looking at the moment is how an arrangement can be structured, if it's possible, which meets quite a strict policy timeline against imponderables of supply. And you've mentioned feasibility studies, and it may be, I'm just throwing this out for consideration, it may be that alternative suppliers could be part of a feasibility study. Would that meet the concern?
Sorry to interrupt, but I would just like to add Green Hydro's main reason for specific performance is to showcase their project, right? But Equatoriana Rand Power is not, their primary goal is not to salvage their failing business. That is not our concern. So I would like to discuss with the minister the policies and how we can accustom and what possible settlements we can come to without compromising our
I'm very happy for you to take time to discuss, indeed, because that discussion may be very constructive in relation to finding a way forward. I think you may be working on an assumption that Green Hydro is a failing company. I've seen nothing in the papers that I've been provided with. And therefore we need to work with that question mark. It's obviously something that you believe. I don't know the basis of that belief, but it's not necessarily something which can be accepted as read. But the most important thing, I think, is for you to discuss with your clients, as you've indicated, the timeline between the policy, which has gone from 2026 to 2027, and the need to match that. So the need to adhere to the policy and deliver that policy for the Equatoriana people with the imponderables of how do you get the e-ammonia, which is necessary for the PEM electrolyzer. So if you discuss that with your clients, is there anything that I can take back to the claimant side? Because at the moment, you have terminated the contract, but from what we've been discussing, it's clearly that there is an opportunity to go back and to reinstate in fact in full, because you would be looking for the plant and options, but against a feasibility study, the scope of which needs to be defined. Can I go back and put that to the claimants, to Green Hydro, and see their response to that?
I think just before that, I'd like to clarify the 2020. So we're ideally hoping that if we're continuing with them, they should be able to deliver within the next year. And in terms of what to tell to the claimants, I think the first most important thing would be to reiterate the price reduction. That is what our company stands by. For us to consider this again, it would definitely have to be at a price reduction. As we had stated before, and they had unfairly submitted an arbitration, it would have to be at 15% or a double-digit number.
Now, can I just test that in terms of the likely response from what I've heard by way of opening and what I've read in the papers? Because the papers make it absolutely clear, and there's no suggestion to the contrary, that what has happened already is that the Green Hydro went into the contract on a profit neutral basis. They then reduced the price further because of a particular contractual refinement, which we don't need to concern ourselves with. But the suggestion or the proposal that any reinstatement of the contract is accompanied by a further price reduction may be a sticking point. Against that, you've told me that you do want this energy strategy and that time is of the essence. Whether that time is driven by delivery times or by the policy really doesn't. We are against time constraints.
Yes. So I think then what we are trying to reinstate to the claimants is that we're open for a discussion about the price. That is also why we're here. So with our demands of the price reduction, the feasibility studies, and we would also like to consider the possibility, as I had mentioned before, about contracting P2G or another local entity, because clearly green ammonia is not up to the task. So if these demands were to be met, we are willing to work with the claimants to an extent where we can have these out in phases of implementation. So it's maybe, this is just throwing this out there, maybe things like we can start by them producing the feasibility study. We put that as a joint press release and we reassure the Equatorian people and the public critics that this project is still feasible.
Now, when you talk about starting with the feasibility study, that's obviously quite a high priority.
Yes, it is.
So I could go back to Green Hydro and say that you are willing to talk, that you are looking for a price reduction of 15%, but that you are open for discussion. And if there can be further negotiations on that aspect, there is an opportunity for the contract to be reinstated. It would be reinstated on a plant and options basis, but that as a high priority, there should be a feasibility study which covers both viability and sourcing.
Yes.
Good. Well, now you wanted to have the opportunity to consult with your clients. This is a good opportunity to consult. I'll go and have a word with the claimants, and I will take the offer or the proposition that you've authorized me to take to them, and then I'll come back to you in due course. Thank you so much. Yep. You've got to go out to this country. Yes. Yes. You go back to your private room. Thank you all so much. I've had an opportunity to talk to EREN Power or Equatoriana Renewable Power, and what they've authorized me to say is as follows, that they are, as I think has been made clear, they are looking for a price reduction, and they have stated that they are looking for 15%. However, they are open to discussion in relation to that aspect. They are also prepared to look at the opportunity for reviving the contract. The contract would be revived on a full basis of plant plus options, but as a very important aspect to all of this, they would want a feasibility study to be undertaken. The feasibility study would be to look at the viability, the ongoing viability of the installation, and they are also concerned about the necessary source for e-ammonia. There is, they do not want, well, they want to look at other suppliers as part of the feasibility study, and there is obviously a clear predisposition. And I'm not too sure how much of a red line it is, but there is a clear predisposition to look for e-ammonia suppliers in Equatoriana. Now, in terms of your primary objective of fulfilling the agreement, there is a substantial step forward. There are other aspects which need to be considered. Let me ask you for your reaction.
That sounds like a step forward. We do want to get this contract moving. I'm not sure what the feasibility, sorry.
Study.
Yeah, feasibility study entails. We'll have to take a look at that. And I take it they want to raise the local requirement amount?
Well, certainly as part of the feasibility study, it was to look at two questions. One is viability. The other is the source or sources of e-ammonia. Now, I've not had an opportunity to go into more detail in that regard because we're looking at matters conceptually at the moment. If this is a course that we can follow, then we can look at the detail.
It is a course we can follow. However, we do want an insurance for the termination, or for in the instance that we do go into a contract or the contract again, we want an insurance for termination to protect us and green hydro, in the sense that something like this would never happen again.
Yes. Yeah.
For their demands, they demanded the price reduction.
What I was authorized to say was that they are looking for a price reduction. The figure which was mentioned was 15%, but they went on to say that they were open for discussion. And that's what I'm able to take back to you in terms of what they're looking for at the moment.
I would still go back to the thing, one of the things that we also actually asked for and demanded, an apology. We really had set straightforward to have an apology based on the circumstances that I've been through, the unfortunate police investigation, and how they detained me, how they took away my passport, how they took all the documents that I have owned, just basis on going into this contract.
As well as the trauma of going daily to the investigation office.
Now, I know that you feel very strongly about that. Obviously, when we last spoke, I wasn't authorized to say anything, so I didn't refer at all to any part of our conversation. When we were last speaking, there were two aspects to the apology, to you and your staff, as you rightly said. And it also ties into the no repetition of circumstances which we've seen happen. There's also the reputational aspect. Now, again, is that capable of being dealt with by way of a personal face-to-face apology to you, or how do you, because we need to see how you feel and how that aspect could be addressed.
This has not just affected me only. This has affected my family, the people who I love, and everybody around me. And even not just the company itself, but me personally, having to go through such thing because of just going into such a contract. It's just unfortunate. Why would such a thing happen just like that? Just going further with just simple contract? This just doesn't make any sense.
I hear the strength of your views. Let's think through how this might work. And of course, we don't know what the other side's reaction is going to be at all. But obviously, no one could go around apologizing to every member of your family. We don't know the extent and the reach of the apology, and also reputational harm and damage does repair over time, and there is a risk, again quantifiable by you, as to whether raising its profile again, in fact, does a certain amount of damage rather than solves the problem. So how do you see what would be the optimal way of an apology being delivered in those circumstances?
I think the best way, for just the same as how it was said badly in the news about our company, I would like that apology to be formed in the same manner and the same way. As also compensation for how devastated and how much I felt just going through this harsh process that had happened.
But you wouldn't want that aspect in a newspaper article.
I would want the formal apology for my company, but I want to be compensated for what happened to me personally.
As well as an admission of how R3 was actually admitted. The documents that were seized.
Now, when you say compensated, are we talking about recognition? We're not talking about monetary compensation, because the essential compensation here would be getting the contract back and revived and reinstated.
For the contract, yes, but for my employee.
Yes.
There are two aspects of it.
There are two aspects, and I'm exploring these two aspects.
Yes, exactly. As you have mentioned, that's what we're trying to go further with.
So if there was a newspaper article which said that the contract was back, it was with the exercise of the options, it was going full steam ahead, it was part of the green energy strategy, that green hydro is welcomed back into Equatoriana, and the whole process is written up in those sorts of terms in the press. How far does that go in terms of allaying the concerns that you have?
I would say for me personally, this would be a good idea for the company. As the company's main subject or main project is just to go further and have more people or more partners to collaborate with. But as I stated, for me personally, I would like somehow of a compensation for what had happened that was unfortunate, and how my passport, me personally, and not having the right also to speak about myself, to even I was detained. I was detained. I was imprisoned.
And how far is the no repetition aspect, which was raised by your counsel, how far does that go in terms of reassuring you? And although you feel very damaged by what happened, and I understand that, whether there is an opportunity, if there is a clear no repetition, for it to be bygones being bygones, and because there is movement forward through the article, through the joint collaboration of you and EREN Power, how far does that go to drawing the sting of your concern, which I understand and I hear, but we are looking at how we can constructively move the project, the contract forward?
I think that would be reasonable, but it would have to happen under some conditions. First of which is marketing about green hydro in positive light. And the second is, which as mentioned, the insurance for termination. And thirdly, as you've stated, they are willing to continue the project, but at a 15% price reduction. We find that unreasonable. And after the government change, the REN Power signed a contract with another company who have lowered their price by just 7%. This company was not even a green hydrogen based company, and it was far more damaging to the environment. So we believe that a 5% price reduction would be a viable option, considering that green hydro and green hydrogen is a far more healthier and a better alternative to energy extraction.
And how much flexibility is there in that 5%? Because you've mentioned the other company giving a 7% reduction. How would you, if it was the same for you as for the other company, is that something that is viable or not?
I mean, considering that the other company isn't really a green hydrogen company, it's an alkaline-based power extractor, if I'm not mistaken. It is far more damaging to the environment. We find it suitable that a 5% price reduction is viable. And furthermore, we have already lost so much. And that's our stance on that.
Well, thank you very much. What I'd like to do is take what I'm authorized to take from this discussion back to Equatoriana REN Power and see their responses. So in terms of the reinstatement of the contract, that is something that is common ground as the objective now. So that's clear. In terms of the viability or the feasibility study, you would want to have more details about what that would be and what would be involved. Yes. But you are open to further discussion in that regard. And indeed, that further discussion of a feasibility study may go some way also to addressing the insurance for termination. You're talking about reassurance that it won't be terminated and there won't be any repetition. We're not. That's it. It's a cast iron reassurance that you're looking for. Once we have the reassurance, if we get there, then that goes. Really addresses the personal point that you've raised, which I understand, but there's an element of bygones be bygones. The other wider company reputational damage could be addressed through a joint article, which would also feed into the marketing, the positive light. And in terms of the 15% reduction, for the reasons you've indicated, you are prepared to consider a 5% reduction and would put that forward, and you put that forward on the basis that there is no comparable reduction, because in relation to the other company that's known about, the 7% reduction was not like for like, because it wasn't a green energy company.
Absolutely, yes.
Now, am I able to take that back, what I've just summarized, am I able to take that back to Equatoriana Renpower and see their reaction in that regard?
Yes, please.
Okay, thank you so much. Now, yes, we are pushing against time. Should we just have to do one more, just bring them back in? And I think yes, I'll stay in role for the time being.
They'll stay here, right?
No. Actually, we'll do one more round with.
Okay, we're gonna try and be quick.
Yeah, I'll be quick. Great, thank you so much. And thank you so much for giving me the time to go and talk to Green Hydro. Where we've reached is encouraging. It seems that there is now common ground between both parties that the contract should be revived and should proceed, and I think on the basis that it would be for the plant and the options. So that is a very considerable step forward in relation to where we might get to. There are certain points which they wish me to put back to you, some of which I think may well be advantageous to both parties. So in addition to reviving the contract, the feasibility study, they've not obviously had an opportunity really to consider the detail of that, and they're certainly open to that as an option, as an element of a mediated settlement. They would want to know more details about what would be included in the feasibility study, and it seems that may well be an area where, although we can't do it in the confines of this part of the mediation, it may be that later on in the day, you as head of contracting or CEO can talk to your opposite number and see on an industry sector-wide basis what would be appropriate. So there is an opening and an opportunity which I think could be explored. The third element is that in view of the history and the fact that the CEO of Green Hydrogen spent some days in prison in Equatoriana, there is a requirement, really, that if the contract is reinstated, then there would be no repetition of that sort of response to any difficulty. It should be negotiated, it should be spoken about, and it's very clear that that is not that risk should be eliminated. As part of the elimination of the risk, there has also not only been reputational damage personally, but there's been reputational damage to the company. And if the contract is restored and revived, then some form of press announcement, press article, the cooperation, the collaboration, the resumption of harmonious working relationships between the company and state-owned enterprise. Again, it seems to me that that may be pushing at an open door, because you may well want that in order to go back to the Equatoriana people so that they are properly informed, so that they know that their government and through the government, through the state-owned enterprise, is acting in their interests, and therefore something which informs the population is in your interests and in Green Hydro's interests. On the 15% price reduction, they are not happy with a 15% price reduction. I am authorized to say that they would accept a 5% price reduction, a further 5% price reduction. And the way that it was explained to me was as a benchmarking against a known reduction by another company where it was 7%, but it is not comparing like with like, because the other company was not a green energy company. And the fact that you're working in a green energy environment is important for you, it's important for them, and therefore the 5% is justified on that basis. Now, because of time, I can't solicit or ask for your responses. And because of time, I probably added a little bit more by way of elaboration than I would have done in the context of the mediation. But we should have everyone back. Yeah, bring everyone back. Great. Well, first and foremost, thank you all very much indeed, because it was pretty realistic. Now, there were obviously certain time constraints. We had, probably by the time we'd set the scene in relation to the course of the mediation, we probably had, I don't know, an hour and 10 minutes, an hour and 20 minutes for something which would extend over the entirety of the day. But you can see how the dynamics of the process work and how the caucusing works. Sometimes the introductory session is real fireworks, and it certainly generates more heat than light. There's a lot of banging of the tables, there's a lot of finger pointing, there's a lot of raised voices. So thank you for sparing us all of that. But just for the wider audience, what you saw was, in that instance, relatively tame. But then you saw two parties standing their ground and being brought into greater alignment. So what did you see? You saw, I hope, active listening, and I would pick up on particular comments which were made. I think something about the company going downhill. Now, that was news to me. I wanted to know what that was, so you jump in. There's also alignment, so that you're trying to bring the disparate views more into alignment. Again, because of the truncated time frame, what we were doing in an hour would extend over perhaps 10 hours, and therefore you can align in a much more gentle, cohesive, persuasive way. In some instances, I felt that it was a bit of a blunt instrument in terms of time constraints. But what did we do? We reached a point where the reinstatement of the contract was common ground. We reached a point where the reinstatement of the contract, plant and options was common ground. We started exploring some of the detail which underpinned that common ground. And when we looked at some of the detail, it was in fact mutually advantageous in a way which you simply couldn't get through a judgment or through an arbitral award. The concept of an article acting as an apology and therefore enabling both parties to work constructively together, that the article may provide confidence not only to the company and the government, but also to the general population of Equatoriana. The insurance, you termed it the insurance for termination, no repetition. I can tell you that in the caucus, the final caucus, there was good body language. I may have had some pushback, but there was good body language in relation to an acceptance that it's probably not the right way to go about a commercial business to lock up the CEO of the other company. So one can learn. Companies can learn from their mistakes. Countries, jurisdictions can learn from their mistakes. So we were at issue in relation to the 15% and the 5%. That I think could be worked on because there is a benchmark out there of the 7%, whether that's whether that is the one which should be sort of standardized for all sorts of reasons. I wasn't able to explore that, but again, even there was some sort of alignment and bringing together. So look, thank you all very much indeed.
Have we convinced you that mediation is the way forward? Yay!
Right, well, the best mediation moot next year.
Okay, great. This is the first time we've really focused on doing a mediation session like this. We've really enjoyed it, so I appreciate you guys. Those of you who didn't get to participate, I appreciate your patience in taking part and watching this happen. Those of you who did participate, I appreciate your enthusiastic acting and taking on those roles. So a round of applause for that. Great job. Do you want to say anything before I wrap up with details, or okay?
Yeah, I want to say, I hope that what you all understand here, that this should make your argument about jurisdiction much deeper and much more careful, because now you know the benefit of mediation. And this is not just a divergence from what we've been working on. This is really important to what we've been working on all week, and it should affect your arguments, and you should go home tonight and think about how it affects your arguments. But I do want to say thank you, Asil, thank you, Michael, thank you to the teams that did it. This is wonderful.
Okay, so I know we're all tired and it's been a very long day, and we've asked a lot of you over the last couple of days, but that's the point of the Mina Pre-Moot, is really the training part of it. Tomorrow, we're going to put our training into practice. So tomorrow starts with what we call the oral argument speed test. I'm not sure y'all saw that on the schedule. What you need to do is be ready to make a 2 to 4 minute argument for each of the issues that you're presenting on. And the idea is, because we haven't had opportunities to do full practice rounds yet, we wanted to get you warmed up to, one, giving an argument where you structure and you be able to say what you're making your argument about, and two, be able to start getting some questions and feel out what it's like to answer some of those questions. So we're going to go through and just cycle through everyone's practice for a little while in the morning, and then we're going to have 2 practice rounds. So every